Now declare open the public hearing of the Standing Committee on Social Policy and Legal Affairs inquiry into the relationship between domestic, family and sexual violence, victimisation and suicide. I'd like to acknowledge the traditional original owners of this land, the Muwinina, yes, thank you, people, to pay respect to those who have passed before us and to acknowledge today's Tasmanian Aboriginal people who are custodians of the land. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. This hearing will be broadcast and the transcript of proceedings will be published on the Parliament's website. For those in person or listening online, please be advised that this hearing may contain evidence that could cause distress. If you hear anything today that upsets or causes distress, please reach out to support lines such as 1800 RESPECT, Lifeline, 13 Yarn, Kids Helpline or other support services. There is also a Parliamentary Workplace Support Service and Employee Assistance Program for Broadcasting Hansard, the Committee Secretariat and for the Committee and its members' staff. I now welcome representatives of the Tasmanian Government to give evidence. For the Hansard record, could you please state your full names and the capacity in which you appear before the committee?
Detective Inspector Rebecca Davis, and I'm representing Tasmania Police.
Catherine Schofield, representing the Tasmanian Health Department, but I'm Executive Director of Services of Mental Health Services.
I'm Courtney Herworth. I'm Chief Reform Lead in the Department of Premier and Cabinet, and my area coordinates the whole of government response to family and sexual violence.
Thank you.
Rebecca Flakler, representing Department of Justice, and I'm the Director of Safe at Home.
Thank you. I'm Louise Muller-Frost. I'm the member for Boothby, which is suburban Adelaide, and I'm the chair of the committee.
I'm Matthew Gregg, a member for Deakin in suburban Melbourne.
And I know we have at least two people online. Mr. Smith?
It's David Smith, member for Dean, Canberra.
Mr. Ng?
And good morning, it's Gabriel Ng, the member for Menzies in Melbourne East.
All right. Do I have Mr. McCormack?
Yes, Michael McCormack, Federal Member for Riverina in New South Wales. Thank you.
Lovely. Do I have Ms. Whitty?
Yes, Sarah Whitting, Federal Member for Melbourne.
All right. Do I have Ms. Cheney? She's Western Australia. It's very early over there. Is there anyone else online that I haven't recognised? Good. Okay. Looks like we're fine. Although you're not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Do you wish to make a brief opening statement before we start the discussion?
Yes, I'll make an opening statement on behalf of the Tasmanian Government. So thank you very much for the invitation to speak with you today. And I know you have received copies of two submissions, one from the Tasmanian Government and one from the Coronial Division of the Magistrates Court. And you're going to hear from the Coronial Division of the Magistrates Court later today. As a small jurisdiction, I think we bring unique insights in relation to how we join up information, both at a systemic level and real time for real people. So we hope that that's valuable information for the committee. And I would also just like to acknowledge the strength and courage of victim survivors who often lead reform, and also pay my respect to people who have lost their lives as a result of family and sexual violence and their families and friends. So thank you.
Anyone else? No? Good. Thank you very much, and thank you for your submission. I was particularly interested in the Coronial submission, since you seem to be doing a bit of work in this area, so that was very interesting. So we've got a series of questions. I'll start off. In terms of your current data systems, what are the most significant limitations in trying to identify domestic, family and sexual related violence-related suicide, and what gaps do you think are the most urgent to address?
Well, I might lead off and then I might kick over to Beck and Kat. I think that there are two things about the Tasmanian context that are important to know. One is that we have a very, excuse me, that's just the bells for
Oh, is it?
for Parliament. We have a very long established criminal justice response to family violence in Tasmania, Safe at Home, and we can talk, and Beck will talk about how they link up data in that space. There is a challenge for us in the non-criminal justice response to family violence. We don't have any systemic way of collecting data. And I know you're going to hear from some of our community service partners later today, and they'll talk about our...
I've just been told that they're having trouble online hearing, so
Okay.
I'm not sure if broadcast can help, and perhaps we could just speak up a little bit. Sorry.
Okay, what I might do is just lean in.
Okay.
So at the moment we don't have any kind of system that collects data from a non-criminal justice response. So even through commissioning of services, therapeutic services, we don't have a system that collects that information. There's probably two reasons for that. One is just the maturity of that network and service system, but the other element is a reticence sometimes from individuals to be part of any kind of government or service-related recording of their information. But given the maturity of Safe at Home, which is our criminal justice response, I might ask Beck to talk about how we collect information in that regard.
Do you want to do Safe at Home?
So Safe at Home was created in 2004 with the start of the Family Violence Act, 2004, we have in Tasmania. And the idea being that no singular area, business unit, department can tackle this on their own. It requires a broad approach. So what we have with Safe at Home is Department of Justice as the lead. However, we have our core key partners, government department across the sector. And the idea is that Tasmania Police, if people report, so it's very important that we know this, it's reported family violence that goes to Tasmania Police. Think of that as the gateway to Safe at Home. So if you make a report to Tasmania Police around family violence, you automatically become put in terms of a client of Safe at Home. So what that means is that, for example, our biggest thing that we have at Safe at Home are our integrated case coordination meetings, or ICC meetings, that happen each week around Tasmania. We have 4 of them in each of the regions, and you literally have, sitting around a table very similar to this, you have representatives from Department of Justice, you have the family violence units from Tasmania Police, you have police prosecution, defendant health liaison, family violence counselling support service, child safety service, education,
Prisons.
the Tasmanian Prison Service, community corrections, if I didn't already say that. And the idea is that we will get the family violence incident, but we will look at all the previous incidents that have come through to make sure that we're looking at pattern of behaviour, not just a specific incident. And it is then for the intelligence of interrogating home databases. So each of those agencies have their own. They'll start to pick up pieces of both the perpetrator, the victim survivor, and affected children, because we cover all cohorts, and we discuss it around what are the risk factors, what are safety and provisions we can put in, what bits of information do each of those areas hold. So it's sort of think of it a bit of a puzzle. Starts to put all the pieces together. So instead of just what the police have seen and dealt with and responded to, this is what we know within the sector of different presentations of those. So then we start to see a lot of red flags come up, one of which would be mental health, previous disclosures of attempted suicide or threats of, and we then, it's a tasking out. So for example, it might be we need to look at further protections which go through the justice system, or it could be child safety, what do we need to do for these affected children, is there something they need to do under their legislation, and they're constantly reviewed through the term or the life of a protective order. So it's not as if we discuss them once and leave it, they come back to the table at every single point, noting that risk and safety will change all the time for a range of different reasons. So that really is the nation-leading model that we have here in Tasmania. It has worked for so long, and a lot of the focus over the last couple of years around that information sharing, which we can do under our Act, is drawing in that really important experience and knowledge of our non-government workers, in the sense that they might not physically be at the table, but they do have pathways in, because they are generally more involved with a lot of these families than we would be in government areas. So really important to draw that in and their knowledge and then put that back out as service delivery for them. So that's a very short explanation of Safe at Home, and I think it's really important to highlight those particular meetings because that really is a linchpin of that information sharing, risk, safety, and case management, if you will, of the different agencies. So that can then highlight the police involvement. Sorry.
Is that for all cases or is it just high-risk cases?
No. Or anything that's reported family violence to Tasmania Police is covered.
Thank you.
Yeah.
And so I can talk more about the gateway and how it comes in, but also what we've introduced probably within the last 12 years under Survivors at the Centre of the Action Plan. So as Rebecca highlighted, yes, the gateway is Tasmania Police, and that's a reporting system of what we call our family violence management system. So if I could run you through a little quick scenario, there could be a Tasmania Police member that attends an incident in a suburb last night at 2 a.m. That system they will enter into, and it will be validated by a sergeant of police before the conclusion of that shift. That system is actually accessible to every single one of those partners that Rebecca mentioned earlier, and I think that's a really critical piece, because what it means is the family violence counselling support worker that is at work at 9 o'clock this morning, they have access to what police have done overnight, over the weekend, whether it's someone from prosecution or the court. So they have live interaction with our policing database. And as Beck highlighted, that is what was seen at the one incident at that time where we've interrupted or disrupted some pretty awful behaviour. What we have over 300 people that have access to that other than police members across our state that work within that space. So that's a really pivotal part of our system. What we also have is the Safe Families Coordination Unit, which is the unit that I manage. Within that unit, those partner agencies that Beck highlighted before also sit in there every single day. So Tasmania Police are the lead of that unit, but sitting within there we have what we call a lead investigator and an intelligence officer from every single one of those agencies. So Department of Health, Department of Police, Department of Justice, Education, or DSIP, so children and young people, but both sides of that. So we have education, child safety, youth justice, all capturing in there. What they do is every single morning they will go through every single incident across all the risk factors, and they will pull together and as a group have a conversation around what are we seeing. Police have assessed this as a high risk. What have we got in the hospital system? What have we got in the ambulance officers' notes that attended that night? What do child safety need today to protect those children? So that happens every single day. As when I say that, business days, every morning. So that risk picture is addressed across all of the services, not just what police identified. Further to that, within that unit, we also have what we call family law court liaison officers, and that is a really significant co-location program that policing organisations and Department of Children and Young People across the country have access to. And that brings in the family law court space, as you can imagine. So many of those matters are not reported to police. And we have officers, individual officers, that attend every single court case in relation to custody and property disputes now under federal legislation. But also that family law court can request particular information around a matter, and Tasmania Police will provide every single thing that we know about those parties, children, and the perpetrator and the victim survivor. So they can also assess when they're making decisions around custody and care that they have the full picture. I can't talk on behalf of DSIP, but they run the same model. And again, it's been highlighted nationally that we run, because we're sitting co-located with the relevant parties, it's an ideal model across the country that they're trying to replicate. The other thing that we do, and in line with Beck's case management, is we've identified that police are not the only ones that are going to see risk on a daily basis, and our education partners within the unit will notify every single school on the morning whether an order has been placed or a child is exposed to family violence. So they will notify each school, the school principal and social workers receive that information. what we quite often see coming back is a referral pathway back into us that's not police initiated. So it might be, we've got some concerns about this family that we are seeing. Can the Safe Families Coordination Unit pull together cross-agency information to highlight risks, prospective interventions, particularly around perpetrator behaviour or access at a school environment, a hospital, those type of things. Another thing on the health side, which we do particularly in mental health, which is important to this hearing, is if there's been a family violence incident reported and our health person that sits in the unit goes, we have a history, we've seen particular interventions in the hospital, what we will do is flag that in the health system, that there is an order present, that this is something that family and domestic violence or sexual violence should be considered at any part of an intake, whether it be a presentation at emergency, whether it be in one of our child and family centres. So it's a really, I will highlight that this relates on, this is successful because of the expertise in the room. We are all working in individual data sets and systems, which, as you can imagine, is quite problematic at times. So, but it's that close network, teamwork, but the legislation that allows us to share that is critical. Yeah.
Thank you. So I know Mr McCormack's got questions, so I might start with you online.
Yeah, thanks, Chair, and thanks for your evidence. We heard the other day in Melbourne about the difficulty of data collection, and certainly you've referenced that this morning. In your evidence,
no, we can't hear you, Michael.
Oh, really?
Yeah, I can hear it down
Is that
there.
better?
Yeah.
Is that better?
Okay, we're just going to problem solve
better?
you. Sorry about that.
Yep.
Perhaps I'll put
You're
you on
right.
hold and I'll go to Mr Gregg.
Sure. Thank you. I was
Okay.
taking a look at your submission at the definition of family violence. Does that exclude violence by children against parents and that kind of spousal and other kinds of violence that many states would classify as family violence?
Yeah, so the legislation itself is isolated when it comes to offences committed or orders that we put in place to that intimate partner violence, as opposed to a child assaulting a parent or relative. What we do is we have children themselves can be affected by family violence under the Act, and they can be protected within an order, but a family violence offence cannot be perpetrated on a child or a child back to a parent. How we deal with that is through other legislative means, through Children, Young Persons and Their Families Act. That's where we will look at assaults and care in relation to children, but we use our other legislative pathways through the Criminal Code and Police Offences Act.
Okay, now those online now can't hear.
Okay.
Okay. Really sorry about this.
That's okay.
He sounds okay in the broadcast, so it's just us.
Yeah, but now they can't hear us. Okay. Can I have someone online just say something so we can tell if we can hear you?
It's Michael.
All right, lovely. Okay.
Gabriel here.
Okay, can you hear us?
I can hear you, Lou, but I'm unable to hear the speaker who was just providing evidence.
Right, okay. Really sorry, we'll have another go at that.
Go again.
Okay, can you hear me now?
Much better.
Much
Yes,
better.
thank you.
We might do that.
Yeah.
Would you like me to start again? Or
Briefly.
yeah, but briefly. All right. So on Hansard, there will be a very long, examination of the evidence I've just given. But look, what I spoke about was the police entry into our Safe at Home system. What to provide more of a nutshell version of that is that police systems are totally accessible to all partner agencies that work within the Safe at Home space. So police will input an incident that's reported to us, and Department of Justice, Health, Children and Young People have access to that live pretty much. So all of our services are able to support victim survivors, but also assess risk, but put in disruptions and hold perpetrators to account, whether it be through the courts or some other way. What we also do within our Safe Families Coordination Unit, which is the area I manage, which also is led by police but has all of those partners in it, we will review every single incident across all of our data sets, whether it be through the Tasmanian hospital system, Ambulance Tasmania, Tasmania Police, the prison is an integral partner to that in relation to perpetrator behaviour, whether through the therapeutics or criminal justice side. And we will assess risk, but we'll also support agencies in their frontline responses. So, for instance, if a child has been exposed to family violence overnight, the school that child attends will be notified immediately. They'll be provided copies of orders, and the school principal and social worker can address the risk to that child and their family. Within the unit that we also have access to family law court systems, of which we input information as well as receive it. And I think that's the best way I could do that very quickly. That was much quicker.
So Mr. Gregg's question was, for those online, was about whether elder abuse and child on parent was captured, and I think the answer was that's under different legislation.
Under different legislation and different
Can I
systems.
ask, is child on child abuse within a
Not
family
within
captured?
our family violence response. It is dealt within the criminal justice or youth justice space more.
So when there is parent-to-child violence or child-to-child violence, is a similar coordinated response available, or is it a very different kettle of fish depending on?
Yeah, so what we have, and this is from Tasmania Police perspective, we have what we call our Child Safety Assessment Unit, and we work very closely with our partners at Department of Children and Young Persons, so Child Safety. So what we do is we share mandatory referrals, but we have coordinated responses together. So that's where that information is shared. It is shared because, one, it's mandated, but two, there is daily updates, management, and that central resource and access for the departments to be able to further prosecutions, care and protection, etc. But yes, it is dealt with under separate legislative frameworks.
Could I just add, the Family Violence Act in Tasmania is currently under review.
Okay.
So there is a discussion paper that is currently out, which is looking at, it is 23 years old, 23 years old.
2004.
So it is currently under review, and one of the areas of review is looking at whether we would expand the definition of family violence under that Act. Obviously, if we expanded it, would have significant operational impacts, given how mature our response is to family violence. Your question about child-on-child related behaviour is important. We've recently had a Royal Commission or a Commission of Inquiry in Tasmania into child sexual abuse. That commission recommended that we not take a criminal justice response to how we deal with children who abuse other children. That the response is a therapeutic response, because often children who abuse other children are victims of abuse themselves. And so the government is currently looking at, we've just developed a framework called the Harmful Sexual Behaviours Framework, which is a nation-leading framework looking at how we bring all of these services together, particularly around looking at children who may be harming others. So whether it's other children or others in their community. But we wouldn't be looking at a criminal justice response. The government accepted all recommendations of our Commission of Inquiry, and they were very, very clear that it would be that a therapeutic response is the best approach to dealing with children who may be abusing others.
So with this coordinated response, because it's criminal justice, does that mean if someone brings up historical violence and things like that, that it just doesn't feed into this system?
No, it feeds into this system. If it,
So if the relationship had ended, for example?
yeah. No, it involves ex-partners, previous partners, absolutely.
Even where there's no perceived risk of continuing violence?
Not on perceived risk, maybe on that victim, but quite often we will see that there will be, a perpetrator with multiple victims. So we see that risk as still continuing, whether it's an ex-relationship or previous relationship. So it will all be dealt with through the same space.
And my final question, with the coordinated response, how scalable do you think that is? Is it because that you have a lesser number of these cases than other states that it's possible to bring these kind of experts into the room? Would it be possible if you had a population that was 10 or 20 times the size?
So what I can say is proportionally the rate of family violence in Tasmania is equivalent to the larger states. So the amount of incidents are the same, particularly if we narrow down the definition to our definition. So what you'll see in New South Wales or Queensland with the broader definition, their reported incidents around family and domestic violence applies context. So in answer to your question, what I would say is the success of this model, if you look at the fatality rates in Tasmania over the 20 years that we've had that, are incredibly low. So that's where we see the success of that coordinated model, the information sharing. We're not seeing those high fatality rates in intimate partner violence. So yeah, I would see, if we were to expand that out, that response system that Rebecca spoke of earlier is something that would be under significant pressure. Yeah.
I will say that the response that we do have, though, other jurisdictions, I believe, could do it, but you'd break it down, for example, to districts. So I wouldn't say a whole state response. It just wouldn't work. I'd break it down to districts, just as we even do here. So, for example, those meetings I told you about, we have our regions. So we have a southeast, a south, a north, and a northwest, and that's drawing also in the local intelligence and knowledge, because, as you know, there are certain little nuances from different regions, especially being quite a rural state as well, and that in itself brings risk factors that might be different to a really high city sort of suburb place, but it could certainly be done by breaking down into different geographical areas.
I think there's a good example at the moment in northern Queensland, Sunshine Coast. They've got a co-located response model in family violence currently, and it should be noted that across all jurisdictions we regularly meet and we work really well with our other state partners, and they are particularly interested in our model, and we share that more often than not, really. Yeah.
I think, though, from a policy perspective, putting aside the specifics of any model, the reason that it works is because you're looking at individuals, and individuals are complicated. And so when you have standardised responses that carve people up, so this is going to be a mental health response, this is going to be a family, this is what that's where you see the system fail, and that's where you see victims who end up either killed or taking their own life. And I think the core of why it works is because the system is geared around looking at each individual circumstance and working through the specifics of that individual and what they need. Now, that is expensive, and it's expensive whether you do it in a small jurisdiction or a large jurisdiction. But like all policy people, I would say that there's a cost, a cost recovery element of it. You're putting a lot into the front end to prevent a lot of things happening at the back end.
Thank you.
Mr. McCormack, would you like to have another go?
Yes, can you hear me?
Oh, we
Yes,
can.
loud and clear.
Wonderful. In your evidence, and thank you very much for that, you mentioned some of the barriers to data collection, and we heard in Melbourne last week that data collection was something that was difficult for any number of reasons, and having nationally consistent data collection was also something that they were, those who gave evidence, or some of them, seeking to get better clarity around. I just wonder, and I've got two sort of questions. What part do privacy issues play a part in data collection? And my second question is about regional Tasmania, and I appreciate that you are the government for the entire state, but I'm just wondering about the difficulty of data collection and reporting of incidents and that sort of thing from country areas, not necessarily Hobart, in your state, please.
Do you want to go from police?
Yeah, look, I can talk this is from a police perspective. The data collection and the response does not change in our rural and regional areas. What we do have is we have obviously that initial report, police will always attend. So it's probably more looking at that broader, the unreported space in our rural and regional areas, which I can't talk to, but that's around your broader service systems and your non-government sector. But anything reported to police will be collected, will be attended, and we have that legislated mandate around the sharing of information that goes across all of those agencies that we spoke of before. What is difficult in the data collection, to highlight the theme of this hearing, is that we don't specifically ask questions within those responses around suicide. There is a risk assessment screening that is done, and within that tool we do talk to that, but it isn't a specific element. It's more of a free text, so to speak. So in breaking, and I imagine like in Victoria, like we just heard, a lot of our data sets around those are questions that we would elicit advice from the individual themselves, same as in the medical space. Yeah, so I don't know, Beck, if you would like to talk to that.
Yeah, I mean, that's the same. We have our Safe at Home information management systems called SIMS. That's our database. So all those agencies that I spoke about, they all have access similarly to the FVMS system, and we share all those. So there are a lot of users between those two systems across the state. Speaking of a rural state, yes, we have representatives in each of those pockets, so it's all captured once again if it's reported to Tasmania Police. So my comment earlier about the importance of a relationship with our non-government sector being really, the linchpin is for that very reason, in the sense that you have we need to provide support, awareness, empowerment to our colleagues in those areas about what to look out for and how to report it. That's obviously only if a victim survivor is wanting to or willing to report formally. And we understand there's a range of reasons why they won't and don't feel safe to do so, which we take very, very seriously, and are doing a lot of awareness and education and being far more outward facing around what we can offer should you choose to report. So it's working with our colleagues in the non-government sector around what can they do to assist those families even prior to a formal report, because there's a lot of safety planning and identifying a risk. They can obviously contact us for de-identified discussions about should somebody be in this situation, what could happen, what would be available to them, what would be the process. And some of that education and support encourages people to go, okay, yep, I'm ready to take that step now. So it's two-pronged, but the actual data collection, if you want to come down to numbers, as Beck said, is problematic because it's a lot of conversation, it's a lot of people's stories being captured, free text, rather than a checklist or a number related to suicide risk gets a 5 in a risk assessment tool. It's obviously captured. We can put flags on our system if we believe there's underlying concerns that could impact matters of family violence. And I know that, I don't know if this forum want to speak to it, but we also have the ARCH centres. So I might hand over to Courtney then. There you go, the lovely segue, because that is not dissimilar. And that was also leading to her conversation around not treating people in silos. So if you're a victim survivor of sexual violence, quite regularly you're going to have elements of family violence or vice versa, and that doesn't mean that you'll only get a service here at Arch and then you have to come over across to us. We work together, so I don't know if you want to talk more about that.
So the Arch centres are sort of based on the Orange Door in Victoria, so they were the sort of inspiration for Arch centres. Arch centres, though, are Tasmanianised, I guess we would say, and they provide an integrated response to sexual violence. It's a and Beck, you'll know the terminology, but it's a it doesn't look like a police station. No. When you walk in, it just looks like a lovely, lovely place to be. It has police in it. It has therapeutic services run by community sector, specialist community sector organisations. It has child safety officers, or some have child safety officers, and so you can walk in the door there, talk to someone who's not a police officer, and say, I want to talk to someone about whatever. It may be a therapeutic person, it may be a plainclothes police officer, and that has enabled a lot more collaboration in terms of response, and also data sharing. They're specific to sexual violence and child sexual abuse, and they were related in part to the Commission of Inquiry I talked about earlier. It is true in relation to Mr McCormack's question that in very small regional and rural communities in Tasmania, enabling any kind of sharing of this information is incredibly challenging. Often in those communities, you'll have people who are in positions of authority that are well networked with the perpetrator. Just because they're in the local football club together or they see each other at the supermarket every day. One of the avenues, and we did a little bit of research on this 3 years ago, that we found in regional communities was the person that was most likely to receive a disclosure was the GP, because it may be the only avenue where a person will go by themselves away from, and it may be the only avenue where a person feels that their information will be protected. And so I know the team, and we were talking about this earlier, what can we do with GPs? And some of our services are involved in a significant pilot at the moment in Tasmania, which I'm sure they'll talk about later today, funded by the Australian government, working with GPs around how we upskill GPs in that area. In terms of the question around nationally consistent data, I know you heard from DSS in Canberra earlier. DSS, of course, are very interested in nationally consistent data, and I always come into these conversations with the view that Tasmania's interest is in Tasmanians and in the real lives of Tasmanians. So if nationally consistent data helps us to do something in Tasmania that's useful, I think probably our interest would be more around what data do we need to deliver a service to Tasmanians. And obviously, coming to your earlier point, the definition of family violence that we hold is different from most other states and territories now, and that does make participating in nationally consistent data collection challenging. So that would require some thinking from us around how we do that. But as a state, and as a small state where resources are limited, we would always balance pumping resource into service provision versus into large-scale data collection systems that may benefit some level of policy analysis but don't necessarily translate into immediate impacts for Tasmanians.
One thing I just want to ensure, just around that definition again around family violence here, we talk about children being affected parties or persons under our Act. What we haven't sort of highlighted to you is what that initiates is a mandatory report to child safety whenever a child is exposed in front of or affected by family violence. So there is a response that's automated from a family violence response to protect children. So I just wanted to highlight that that is a part of it's a mandatory legislative requirement. So quite often, you know, where the perpetrator and the victim survivor themselves may not report, there may be where a school or a social worker or a member of the community in a service sector has become aware that a child's affected, and that'll kick off that mandatory report through to child safety. So there's just that arm as well. I just thought I'd highlight that because we didn't mention that.
Automatically added, or it has to have the additional report from the school or social worker?
So they'll have a mandatory report under the Children, Young Person and Their Families Act and the Criminal Code that they must report anywhere where a child is affected by family violence. It's determined as a form of child abuse in our state. So therefore that is reported back within to the system. So it does circle around in another format, but I just wanted to highlight that they're not separate, totally separate from that.
Anything else, Mr. McCoy?
Thank you very much.
Lovely. Mr. Ng.
Thank you, Chair, and thanks to the panel for making the time to speak this morning. Apologies because I can't see you. I'm not sure who was speaking at the time, but just in terms of what one of the speakers basically about it, the best use of resources at national data reporting provides some benefit in on the ground. Could I just ask, what would be required from a reporting data in order to provide the kind of data?
Gabe, you're breaking up quite a bit.
Okay. I'm not sure. Is that better?
Yes.
Okay, great. Thank you. I'll start the question again. So But, one of the speakers before was just saying that in terms of the national data reporting requirements, particularly from DSS, that maybe it wasn't worthwhile from a state level or wasn't best uses of resources from a state level unless it was going to benefit, the delivery of services. Can I ask what would be required from that data to make it worthwhile to go through the cost of having to provide further information to a national data reporting database in terms of would it need to have information about timeframes of greater risk or certain demographic data? I'm just interested in what could help with making that data worthwhile for both parties.
I'm happy to answer that. I think there's two parts to what you're asking. It's what would be worthwhile in the data, but then what's required to collect it. So if we take a step back, the challenge we have in Tasmania is less quality data and more any data. And so unlike DSS and the Commonwealth, where when you commission a service you have DEX or one of your major systems where you report on the outcomes of your investment, we don't have any kind of IT or system infrastructure that enables that. And so it's very labour intensive for services to collect that information and report it back to us. And when you're dealing with an organisation that may have 3 staff. If we fund an organisation in the Huon Valley in Tasmania, it has 3 staff. It's the major therapeutic service centre for that region. We wouldn't want any of those 3 staff doing data collection when their wait list is 6 to 12 months to see someone. And so in a very resource constrained environment, there's the issue of additional resources to collect and record data. There's the issue of systems that support that in the most efficient way. And then there's the issue of quality and use of data. What would it help us in terms of systemic data collection? All the things that you would expect, but demographics would be one of the most important. In a small jurisdiction, we often do kind of, as I like to say, we don't fragment our services. So one service, a mainstream service, will provide services to all different cohorts of people in all different places because we don't have the scale that would enable a lot of specialist services. Information about demographics helps those services become more sophisticated in terms of how they do that. But data collection, the Commonwealth has consistently moved to more and more data. They want more and more data out of states. We absolutely recognise the need for that at a policy level and on a national level, but there is a lot of infrastructure that needs to be built around that to make that useful. And in a small jurisdiction, when we're balancing wait lists, people's lives, that tends to be, whilst it's a priority that's not as immediate because we are dealing with frontline services who are small and need the full amount of resourcing that we or through the federal government can provide.
No, I understand what you're saying about prioritising delivery, absolutely. Can I ask, of the current systems, you mentioned data exchange, but also in your submission, the Australian Institute of Health and Welfare, there's ABS, perhaps other systems. Are there any that are the least impost that provide worthwhile data, that have the most promise?
I have to be frank, in this area, ANROS would be one of the best sources of data for us. ANROS consistently provides probably the best data in terms of faceting it to our context. So they're the most flexible in terms of being able to think about Tasmania, but also translating data into some sort of practice impact. So AIHW is probably less focused on translating data into having an impact on practice or service delivery. ABS, similarly, it's the facts and figures, and then someone else has to take it away and turn it into something meaningful. ANROS, on the other hand, has a much more strategic focus on how do you take that information and turn it into something that will impact people's lives. And that's what we're interested in. In a small jurisdiction, we don't have an infrastructure that would enable us to take data and then develop it into a whole lot of systems and programs. We're interested in how people can help us do that. And for us, ANROS, it's certainly at a policy level, ANROS would be the best source of that for us.
Thank you. On another note, we heard evidence from some young advocates talking about because they were often sidelined or considered secondary victims in the mainstream family violence system, they suggested it might be necessary to have family violence support specifically for young people. So just in your model, I'm wondering about how you support young people, provide them with agency, and your thoughts on any need for possibly separate services for young people.
I think for us, this is we're probably a little bit different because we have had a commission of inquiry into child sexual abuse. So whilst family violence is more than sexual abuse, that commission of inquiry really put a spotlight on children, both as victim survivors in their own right, but children who use abuse as a way of use abuse in their own relationships. As a result of that, I think that our response is relatively nuanced at this point in time. So we have so, for example, the Arch Centres have been heavily informed in their design by children and young people because they were part of a response to child sexual abuse. We have funded our Commissioner for Children and Young People to provide us with standing panels of young people that can inform our service delivery in these important areas. The Department for Education, Children and Young People is a partner in all of our work, and again they are very focused on child voice and providing a voice to children, and a number of our therapeutic services have panels of young people or mechanisms that inform their service delivery around those young people. So I know at the national level there's a lot of conversation about child voice, and I know the National FDSV Commissioner has looked at or has recently done some consultation with children. I would say that Tasmania is really ahead of the game in that area, and we also are about to bring online a new Children's Commissioner with substantial increased powers in terms of considering the role and rights of children in service delivery generally. So.
Thank you. That sounds very promising. Can I ask, one particular issue that was raised by young people was a perpetrator often being notified if, those mandatory reporting requirements were there, notified by schools or, say, by hospitals. How is that something that you guard against and balance with, I suppose, parents' rights as well?
That's a really important question. Look, I think I'll turn to the way we case manage and we consult with our partner agencies. I think, as Courtney highlighted before, nothing we do in this space in relation to children or family violence is siloed. And what we would do is take, and I know in the school space, if there is a crime or an offence committed, we certainly work with the school, we work with child safety to find, and the families and parents to work out what the best response is. We have had recent incidents where certain trends you'll see in young people and their relationships. And what we do, we don't take that punitive criminal justice approach. We do wholly, collectively go down that education path and that care and protection. But yeah, I would say it sits solely in our case management space and that information sharing across all of us. I don't know if Beck or Courtney, you wanted to add anything to that?
Just on top of what we've already spoken about before, it's that risk assessment and safety planning that is done through the whole trajectory. And as I said, it's not just about the perpetrator or the victim survivor, it's children as well, that we have the 3 cohorts. So you might have some services who are around the intervention for the perpetrator. You've got rehabilitation support for the victim survivor, but similarly you've got the same for children. So a lot of the services that I spoke about before who are a part of our weekly meetings, for example, they have child-focused programs specifically. So children, for example, if children are victim survivors of family violence, they're not put into adult programs of family violence. It is geared trauma-informed and around their vulnerability as a child and seen in their own right around therapeutic and support for them. As far as any intervention if they are a perpetrator, it's around that education, awareness, behaviours, patterns, health needs, to a point where we can, and Bet can speak to this, about police intervention for our young people who are about 16, 17 mark, who are offending and causing harm as perpetrators of family violence. Beck, I don't know if you want to speak.
Yeah, look, what we do quite often with that, under our legislation, we can put protective orders in place. And with the protective orders around that younger cohort, we would really consider the type of conditions that are placed on those, because you're looking at children that may be at school together, that any impact that we put from a justice perspective may impact their education, may impact their health needs, etc. So what we try and do is work together, get all of that information that's important. But there are at times where there has to be some intervention, but we try to, and this is not a very scientific term, but we don't want to set anybody up to fail, whether they be a young perpetrator or a young victim survivor. So, and it's also understanding the nuances and the technology that's quite often involved in their relationship and their perpetration of abuse. It's more often than not that it's not physical or it's not overt. It's actually through the technological space. So that just opens up other, avenues for education, support, that type of thing. Yeah, it's a very different form of violence that we are seeing.
Thanks very much. That's all the questions from me. Can I just say the integrated case management model that's targeted at individuals sounds like it's got a lot of promise, and it's clearly the result of a lot of hard work. So well done.
Thank you. We've only got a couple of minutes left, but I did just want to ask one quick question about standardisation of data, recognising that collecting data is difficult, but where you're already collecting data in, for instance, health records, etc., is there any look at the standardisation of data so that it is easily collected in the worst possible set of circumstances by the coroner's court? What we've heard, and I think in your submission, you noted that threats of suicide are currently considered as emotional abuse. We heard from other evidence previously that a family domestic violence relationship might be relationship issues, and child sex abuse might be a troubled childhood. And so that makes it really difficult to actually understand what we're dealing with. Is there any thought about just standardising how data is collected and what's written down?
I think this is really complex in relation to when we receive the data, and we only had this conversation just before. If a police officer or a medical practitioner or a teacher places their own standardised language across what's reported to them, this is where gaps fall and we miss really pertinent information. So we've just talked about recently state consistent training that we're delivering around coercive control and emotional abuse. And what we've found through storytelling and going through a case is that we actually don't want, other than for medical things, and I'll let you speak to that, but we don't want our practitioners on the front line to standardise their language or how they report something, because that is, it's not in the words of the victim survivor, and it's not able to translate to a legislative evidence-based language. So that's really complex, and I think if we standardise things, you will have frontline responders, and this is purely speaking from police. We don't want a tick and flick, because in the tick and flick saying, is this present, is that not present, is this present, that will result in things being missed, and also it doesn't educate our responders to actually identify those broader aspects. But I don't know if you wanted to say something about that.
I don't think there's much more to say, really, but obviously when somebody presents with a mental health issue, the primary role is to look for the mental health concerns and the issues and how that can be treated. So it's seen very much within the medical model. We are seeing more, I suppose, disclosure in the softer spaces where people are seeking help rather than seeking mental health help specifically. But yes, our screening tools probably aren't very comprehensive or sensitive in many ways to disclosures or even to heighten the awareness that it might be partner violence or some kind of violence that's occurring in those situations.
And I think back to Beck's point, all of these different service systems have their own language that they use to describe different events in people's lives, and that comes with, and you may hear this later in the day, some service systems reject the language used in other systems and consider that language to be either oppressive or to perpetrate the conditions that are creating violence. So this is actually an incredibly complex area to try to standardise, and in a way, as Beck said, it's sort of a kind of path to nowhere. What you actually want to consistently get back to is what you're hearing from the individual, and less standardising the language, more standardising the capacity to listen to that individual and work out what it is they're saying to you. And that comes back to training, which is what our system has been focused on around what is coercive control. What does that mean? If someone's telling, having a response that, well, every time I say I want to go see my friend, they say they're going to kill themselves. What does that mean? I think is really core, and it comes back again to the point that it's difficult to standardise effective responses to this issue because it's highly individualised.
And I think that those data entry points, what do they look like? So they're different again. So the data entry point for police is in a highly volatile, dangerous matter. To your point around the health condition, we're assessing what's the critical need for safety right at that time. So it's sort of in the cold hard light of day in the following days where we draw all of that in together. So yeah, couldn't agree more, Courtney, around that. It's very complex. And what we're seeing, like I mentioned before in the training that we're delivering, is we're seeing and we're training police, child safety workers, educators to be curious, ask questions, but they are case by case. They're affiliated. We need to educate and provide them with the training and skills to elicit that free narrative, to elicit those things, as opposed to a text box with a particular type of violence.
Okay. I just the comment that we got from the victim survivors, and this was young people, was that they felt that it had been soft pedalled by saying troubled childhood. That they hadn't dealt with.
Absolutely.
No objection. Absolutely.
No objection. And I think you'd hear, and where that's heard as well is really important to them. It might be something that they hear in a court space, by a defence lawyer and stuff, and we totally understand and hear that that's,
But that also comes back to ideas about how victims should behave, which is highly gendered. If you, and this is an issue that police face all the time, if you turn up to an incident and you have two people that are being violent toward each other because one of them is highly dysregulated, they're angry, they've had enough, they've been pushed to the limit, it comes back to, well, that could easily look like, who is the aggressor here? Right? So these are very and it's a heightened moment, and safety is at risk. These are really complicated, and it comes back to the unpacking
in the
what's
days and
happening.
that case management that we're talking, misidentification and when we talk about that youth space, we add another layer of complexity.
It is now 10 o'clock, so I'm going to have to call it to a halt, but thank you so much. It's been really, really good conversation. So thank you for your attendance today. If you've been asked to provide any additional information, which I don't think we did, including questions on notice, please forward it to the Secretariat by Friday, 8th of May 2026. Please note that responses to questions on notice will be published on the committee's website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering any questions, and you'll have an opportunity to request corrections to any transcription errors. Thank you all so much for your time today. Thank you. Are you the Coronial division? Oh, come on up.
Good morning.
Morning. I now welcome representatives of the Coronial Division of the Magistrates Court of Tasmania to give evidence. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
Jane Suzanne Cook, Administrator of the Magistrates Court of Tasmania.
Thank you.
Vernie Larasati, Senior Research Officer at the Coronial Division of Magistrates Court of Tasmania.
Thank you very much. Although you're not required to give evidence under oath, this hearing is a legal proceeding of the Parliament. It has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Please note that information in relation to ongoing investigations or cases should not be divulged in order to avoid potential interference, which I'm sure you know anyway. I will let you know that, I'm the Chair, Louise Miller-Frost. You've obviously got Matt Wegg. Online we have Mr McCormack, Mr Smith, and we've just lost Miss Whitty, so we'll take questions and then go online. Did you wish to make a brief opening statement before we start?
I have prepared a brief opening statement if the committee was
Please.
interested. Okay, thank you. Thank you, Chair. I'd like to begin by thanking the committee for the opportunity to attend today and to provide a brief opening statement on behalf of the Magistrates Court of Tasmania, under which sits the Coroner's Court of Tasmania. I just wanted to first acknowledge the Aboriginal and Torres Strait Islander peoples, first people and traditional owners on the land on which we're meeting today, and pay my respects to all Tasmanian Aboriginal people, the traditional owners of the land on which the court operates and this committee sits today. The Magistrates Court of Tasmania is established by way of the Magistrates Court Act 1987, is comprised of 17 magistrates sitting across 4 permanent registries and supported by 72.4 FTE. The court sits as the Court of Petty Sessions, a court of summary jurisdiction, and the court's other divisions include Civil, Youth Justice, Children's Division, and of course the Coronial Division, established by way of the Coroners Act. 3 of the 17 magistrates sit full-time as coroners, albeit other magistrates also undertake coronial work from time to time. And they're supported in their work by a team of 15.4 FTE, including 2 staff who manage the Tasmanian Suicide Register, which, as you probably just heard, is a joint partnership between the Department of Justice and the Tasmanian Department of Health. My role is as Administrator of the Court, a role established per Section 16 of the Magistrates Court Act. I'm responsible for the administrative management and operation of the Magistrates Court. And obviously Ms Larasati appears as the Senior Research Officer at the Tasmanian Suicide Register who leads that project. I just wanted to formally acknowledge briefly at this point, before discussing any data, that in the court's submission that each number represents an individual life lost, life which was valued and will be missed. I acknowledge circumstances relating to a suicide are really complex and multifaceted. There's not often a single reason why a person chooses to end their life, and that deaths by suicide are preventable. For that reason, I'm grateful to the work of the committee. Thank you.
Thank you. Can I just start by asking, so you had the Tasmanian Suicide Register, and there was a particular report on the experience of family violence during 2016 to 2020. Is that evidence collected ongoing, or was it just a specific period of time?
So the evidence collected is ongoing. We have 2 data sets within the Suicide Register, which is the core data set, and then we have the enhanced data set. So that's kind of like once an investigation into the death and it's determined as a suicide is completed, the Suicide Register code that coronial brief. So it's kind of like the comprehensive coding, so to speak. And so that data set is completed up to 2020. Our coder is currently completing coding for 2021 onwards. So we do have a little backlog in terms of suicide coding.
And in terms of the aspects of the current coronial data collection processes, what aspects most limit your ability to actually reliably identify domestic, family, or sexual violence involvement in suicide deaths, and how would you suggest improvements to that?
So in terms of identifying evidence of family violence, our coder goes through the coronial brief, as I previously mentioned. And so the coronial brief includes sources such as coronial findings. We have the police report of death. We have the police subject report, medical records, the forensic pathologist reports, and often identifying evidence of family violence is quite an explicit evidence where, for example, a police affidavit might say this person perpetrated family violence. Sometimes there's police records against it. And so sometimes it's also within the family or friend's affidavit. This person has told me that I experienced abuse previously, or
So that's how we kind of identify the evidence of family violence. I think in terms of improvement, I think experience is definitely one that is, I find personally to be useful. The more you read coronial briefs, the more you understand the issue. I think with family violence as well, there's a lot of nuances that sometimes someone who's not necessarily a family violence expert is able to identify, but usually from my experience with the brief, evidence is typically quite explicit.
Right.
Yeah.
Okay. And our terms of reference is family, domestic and sexual violence, and obviously trauma has a long tail. In terms of looking at, what might be a contextual sort of situation under which somebody has to, suicided, how far back do you go?
We're at the mercy of the coronial evidence in the coronial brief. So sometimes this is divulged, and sometimes childhood trauma can be divulged within the affidavits. So, for example, a person might have told a family member that, look, I experienced this as a child, or a family member is aware that this occurred. So it varies, but sometimes we do have evidence all the way back from childhood.
And of course, you might be doing that initial look at the file before the coronial proceedings have concluded, and of course, pending. You're looking at police reports and medical evidence and things initially when it's reported to the coronial division before the coroners have been able to complete their work. And of course, they're not bound by the rules of evidence in the same way another court is in the criminal division, so they can sort of go where the evidence takes them, particularly if it's a matter they determine requires an inquest. So that's what I think you're talking about in terms of your enhanced data set once that's completed. And
sorry, can you just speak up a little bit?
Sorry, it just depends. Once the coroners have finished their work and all the rest of it, that's I think what Ms. Sarasat is talking about in terms of the enhanced data set and what that looks like once the work completed.
And so, you were here for my question to the last speakers, but in terms of the coroners looking at evidence, how much judgment do they put into it? And I'm going back to that question about where the records might say troubled childhood or relationship issues or emotional issues or that sort of. How much judgment do the coroners actually put into trying to understand what that might mean if it's not explicitly in the records?
That's a hard question, as I'm not a coroner.
Oh, okay.
But in my experience, they tend to, and this is, they tend to be really, really thorough and sort of in their findings. And if they're a lot of our findings are published, they sort of will go to what was sort of put on them and what was sort of mentioned in the file, and then they will go down various whether or not they felt that materially contributed or that sort of thing. I tend to, but without being unfortunately, Rooney and I are not coroners.
No, I just wonder if there were like standards or guidelines for them in terms.
They're bound by the Act. I'll note at this point the Tasmanian Coroners Act is with the Tasmanian Law Reform Institute for a review. Right. I understand that is expected to be completed at some point this year. Albeit I haven't had an update from the Law Reform Institute in relation to that. So the Act is sort of 30 years old now. So that has been referred by the government to the Law Reform Institute. So, and I understand they're looking at all of this.
Okay, that's good to know. And then one more question, and then I'll pass on to my colleague. In terms of what the coroners are putting in, sorry if I'm going into the same area again. I'm assuming that, well, actually, no, I won't assume. Do they differentiate between what they think might have been a contributing factor versus we understand that this was in the context of family violence, but they don't necessarily have, there's a history of family violence, may not be a causative link?
They required and they do sort of look at all circumstances in relation to a death. So if that evidence is there, I would, without being a coroner, they do tend to take a pretty broad look at all the circumstances that would lead up to a person's death. And if that's where the evidence goes, then but without being a coroner.
Fair enough. Thank you. Mr. Gregg.
Thank you very much, Chair. I'm aware that an individual can kind of have touch points with many different services, and the coronial brief doesn't know what it knows. For a few years now, we've had the Australian Death Check as a means of data matching between services. How effective do you think we are at coordinating collection of relevant data across services, government-funded community organisations and other systems? Are there proper alerts that exist, or do you think we could better utilise those tools to identify where touch points have occurred during that person's lifetime?
The court tries very hard, and I've been in my position since October, but the court generally works very hard with all its stakeholders to try to share information where appropriate and where we are able to. In relation to the suicide register, I know that they've got really close relationships, particularly with the Victorian Coroner's Court, and in fact our suicide register model was modelled on the system in Victoria. I think it's acknowledged that the working in collaboration and making sure we've got shared definitions and a shared understanding of what we're doing is certainly something that would assist. If that's the point of apologies if I've missed.
No, that's all right. I'm thinking also from a service level. So, for example, we have an alert in the system that a person has died.
Yes.
How do we ensure that every service that person has used within Tasmania is aware of that death and knows that we may require information about that person if they've got it? So the death check is best utility is matching the fact of death with any files that service provider may hold.
Yes.
So it's making sure that we're able to collect as much evidence as possible about that person's story.
Yeah.
Has that been effective, or is there a lot of organisations that the person might have visited and we just won't know?
I think that's certainly something that the court would appreciate resources to help do. That's something I'm happy to take that on notice in terms of our police associates and what they might do and what they might look into as part of their preparing their report on death.
Yeah, that would be
I'm not sure if you've got any other information in relation to that, Rindy. Otherwise, I'm happy to take that on notice. We do have police associates who are police sergeants who sit within the Coronial division who prepare that report of death and work with police. I'm happy to
that'd be
seek
great.
some
Thank you.
procedural information from them.
Yeah, certainly. I think if, from my understanding, if the coroner feels that a certain service contact is relevant to the death, then they will investigate that record. So, for example, in terms of family violence, if the deceased was involved with police interaction, for example, and there was a record of family violence within the police records, and that's typically provided and available for us to code. So, I think there's some if it was determined as relevant, from my understanding, but. As Jane said, I'm also not a coroner, so yeah.
That's understandable. You mentioned before that there are good relationships with service providers in other states. I'm aware that a lot of people come and go from Tasmania. Are the systems for cross-jurisdictional evidence collection, have they been working effectively, or is there sometimes some difficulty in some clogs in trying to collect evidence about a person when they've kind of moved across jurisdictions?
I'm not aware of data sharing cross-jurisdictionally, sorry.
Okay, that's all right. No, that's fine.
Yeah.
Do you think that there's an approach you've seen either in Tasmania or in another state that you kind of wish that we could just adopt nationally? Like any best practice or effective examples of good data collection and good integration of information that you kind of wish we could replicate if we had all the money in the world?
I've seen some data linkage by the New South Wales Suicide Register, and this is not kind of family violence context, but it is within the health context, and I thought that was quite fascinating because it's in comparison to the Tasmanian Suicide Register, they were kind of miles advanced, and that's something that I looked at, and I was like, that actually would be something that would be amazing for us to do. But yeah,
we're also in the process of upgrading our case management systems, both from a criminal perspective and in a particular coronial perspective, and I'd be really hopeful, all going well, that we are able to have that up and running within 12 months, and that will hopefully mean that we, in terms of the speed with which we can input data and the meaningful reports and that sort of thing would be really helpful, certainly from a criminal perspective as well. We are in the process, albeit that's got a bit of a longer lead time, upgrading our case management system, which would mean that we'd be able to capture more data around all the matters going through our criminal division as well, particularly as it relates to family violence, which is a huge part of what we do in the criminal division.
That makes a lot of sense. Thank you very much.
Thank you. Mr. McCormack.
Thank you very much for your evidence and your submission. I appreciate that your data is based on statistics that are given in good faith, and it's very regimented. I just want to though ask, as a regional member, as a person from a country area, and appreciating that Tasmania is about as big as actually my riverine or electricity New South Wales, how much more difficult is it to collect data from country areas of Tasmania? Has there been any interpretation, I suppose, put on regional reporting of suicides in as much as the actual cause. And what I'm trying to say is, do you think the data that is collected from the regions is more difficult than that which would be collected, I guess, from the state capital, Hobart?
In terms of process, I'll firstly say where a portable death is that the forensic pathology is based in Hobart. So if someone's died, the body will always be brought to Hobart. In relation to data, and Ms. Larissade can comment more than us, we do have to sort of sometimes be careful about if it's a really small town and publishing things that may identify particular persons. The Coronial Division do a lot of analysis. I know Ms. Larissade has recently completed some work in relation to firearms deaths and all the rest of it. So we do try with the resources that we've got to do lots of things. But in terms of the centralisation, the government made a determination a while ago that yes, where a death occurs, obviously the mortuary ambulance and all that, those are run out of the Coronial Division, and the bodies will be brought centrally to Hobart, where an autopsy, where required, is conducted. So that's all done sort of out of Hobart. But yes, there are parts of Tasmania that are pretty far and remote. I hope that answers your question.
Can I further ask, please? With the you mentioned autopsies. Where are autopsies actually conducted for suicides or for any person really in Tasmania? Are they, dare I ask, are they all done at in Hobart, or are they at Launceston and Devonport availability for people who have passed away, and are autopsies also conducted there, and particularly specifically for suicide?
My understanding is that in September 2020, the state government centralised statewide forensic medical services to the Royal Hobart Hospital, and all bodies from across Tasmania which are referred to the coroner for examination will be transported to Hobart. So that includes people where previously that would have been done at the Launceston General. Part of the work of the Coronial Division, of course, is facilitating transport of those bodies back to the families and the senior next of kin for respectful burial. And we work very closely with senior next of kin on the Coronial website. We've got quite a lot of information, and we've got a staff member, a Coronial liaison officer, who, where a death is reported to the coroner, will liaise with sort of the family. It may be the first time, for example, that they've had anything to do with the court, anything to do with the Coronial Division, then that role it helps work with the senior next of kin as to what happens and what they can do and what the processes are, and guides them through the process, which can be inherently quite a stressful experience, particularly when you've lost a loved one.
Thank you.
Okay, Mr. Ng.
Thank you, Chair, and thank you to Mrs. Cook and Ms. Larissade. I was just wondering, in terms of just expanding on the question that the Chair asked about avoiding family violence or sexual violence related suicides, just kind of being captured as troubled childhood or domestic problems. Would it be viable for systems or training to be put in place for coroners to better consider or assess the role of domestic, family and sexual violence in any suicide?
I think sort of the more data and information that can be provided to a coroner to consider would, I'm sure, be really helpful in piecing together what has occurred and may have occurred that was relevant in the lead up to their death. Certainly we do.
So you consider that the things might be coded that way because of the information the coroner receives, and not the coroner providing a summary of some of the information they receive that doesn't capture all the circumstances of the suicide?
So we have a variety of variables, kind of data fields on the suicide register, and so for example, with relationship and instances of violence, those are two separate kind of domains, and which we could kind of interpret separately as well. I don't know if that kind of answers the question, but so then, yeah.
As we work through a new case management system, I'd be confident that I would be really hopeful that we could broaden sort of the fields of what we could code and the processes by which we do that. I'm grateful to the Department of Health, who have provided us some additional resources to put in place, another staff member to help with the coding and we do have a bit of a backlog of coding at the moment, but certainly the more information, so the better. But we are constrained slightly by our systems at the moment, and I'm hoping, as I say, got a plan in place to hopefully have a more modern system within the year or so.
Sure, thank you. And my second and last question was just, we have heard how fragmented systems can sometimes mean that people fall between the cracks. How effective is the Coronial inquest and the Coronial recommendations in picking up where there's been these system failures and making recommendations as a result?
Our coroners under the Coroners Act 1905 have very broad powers to investigate. Then, as I say, they're not bound by the rules of evidence, and they, I know the coroners in Australia, we're actually hosting it in Tasmania later this year. All the coroners from around the country, and then later in the Asia Pacific as well. I know they get together sort of biannually to discuss all of these sort of matters, and they have really good relationships. And so the Coroners Act does give them pretty broad powers to investigate any systemic patterns, and I know they do. And the division will sort of they'll publish recommendations, and the division will sort of follow up with outputs where a recommendation was made in relation to a safety recommendation or whatever. They will follow that up with the agency.
Sure, thank you. And based on the data or information that you've considered in relation to domestic, family and sexual violence and suicide, were there any systemic issues that you identified?
They would be matters sort of really that we would seek to work through with the coroner. So this is actually the first time that the Tasmanian Coronial Division has been able to prepare this a data set of this sort of work, which was done for the benefit of the committee. So we would still work. We would like to be working through that, and we'll work through that pretty closely and continue to do that with the Chief Coroner and the coroners who considered to do that analysis. We would have liked to have done a bit of a deeper dive, but with the time we had, we didn't. This is what we were able to do, but we'll continue to work through that. But yeah, no, this is the first, I think it's mentioned in our submission, this is the first time Tasmania has been able, we've had the resources and the numbers, albeit we do have a small population, but been able to put together analysis of this nature for Tasmania. So that's quite exciting, and keen to continue to do that work and to do that analysis in conjunction with the Chief Coroner.
Understood, thank you.
Thank you. Mr. Gregor, I think you had another one.
Yeah, I was just wondering, in terms of, we're obviously working off some fairly old legislation, are there any current roadblocks with evidence collection around legal professional privilege or information provided in the context of family court proceedings in the Commonwealth jurisdiction? Any kind of legal impediments to useful evidence collection you're aware of?
Just have a quick look at the legislation. The Act is very broad, particularly. So Part 7 of the Act goes into sort of conduct of inquest and sort of the broad powers that the coroners have. And as I say, that's something that the law reform, the Act in its entirety, including all of the powers of it, to look at the structure of the division, whether you need additional statutory functions, and the powers of coroners are quite broad. Because
I'm conscious that with exemptions like legal professional privilege generally, unless the legislation explicitly ousts it, the presumption is that privilege continues to apply. I mean, that's probably a bit too technical, so I'm happy for that to be on notice.
Look, I might have to take that on notice in relation to that.
No worries. And the family court proceedings that are Commonwealth, governed by Commonwealth.
Yep, I can seek some advice on that.
Thank you very much.
Thank you. Okay, a couple more questions. So you mentioned working with the senior next of kin in terms of how do you deal with if the senior next of kin is potentially the perpetrator in a family domestic violence situation? Do you have any sort of awareness of that, or?
Well, part of the work of the coroner is, and this is a matter that ultimately sits with the coroner and the presiding coroner. It's their information, it's their code, it's their data, and all the rest of it is part of their role is to determine who is the senior next of kin. That can often be a complex pathway, and so the conduct of an investigation, including the conduct of how staff deal with the senior next of kin and other interested parties in relation to a matter, would all be done at the direction of a coroner. Who obviously have considerable training and experience in a range of different matters, including this sort of thing. So it would be a matter that would be discussed very closely with the coroner and done at the direction of the coroner.
Okay.
particularly in terms of deciding who the senior next of kin is, and that can often, as I mentioned, often be a complex picture as well. And then how that's done, so that would be done at the direction of the coroner, if that is
right. So if from a legal sense the senior next of kin is actually the perpetrator, are we stuck? Is it still? Sorry, this was raised by particularly a number of family members in the lived experience sort of submissions that we've received, where, for instance, the parents of somebody who had suicided said that the perpetrator basically took control of the entire process, took control of the estate, the body, etc. And there was no recognition that actually this person was the perpetrator and the other next of kin were excluded. So I'm just trying to explore whether there's any leeway there, or are you just legally stuck with, well, that was the, husband, wife, whatever, that is legally the closest next of kin, therefore they have to be the senior next of kin.
I would have thought the Act is fairly broad in terms of determining who is the senior next of kin. As I mentioned, that is a role for the presiding coroner, and that would be something that I know they do seek submissions in relation to, so particularly in determining that, and they won't just talk to the senior next of kin, albeit and as I mentioned, that's the process by determining who the senior next of kin is. And obviously they will also liaise and take into account the views of other interested parties as well.
Right. Okay, thank you.
I would have, without speaking to specifics, I would have thought in that situation they would be seeking, and I know they do seek submissions from all range of people, and that's the process they go down without being a coroner, or speaking for the coroners, to determine who the senior next of kin is.
Great. And in terms of your records, do you differentiate between the suicide of a potential perpetrator versus the suicide of a victim? Is that data pulled out, or is it purely suicide in the context of a family domestic violence situation?
So in the suicide register, our dataset fields are quite general in terms of its evidence of violence between partner and deceased, or evidence of violence between family and deceased. So it's for either victim, perpetrator, or both. For this particular submission, we went through every single record and determined whether the deceased was in fact a victim perpetrator or victim perpetrator.
Right.
Yeah.
Good. Thank you.
Obviously, I know as well that coronial proceedings, where there's criminal proceedings involved, will inevitably not commence until the conclusion of those proceedings. And under our legislation, the coroner cannot reach a determination that's inconsistent with the finding of a court in a criminal proceeding.
Right. Okay. So you would have some determination already to work off.
So so there would be that. So and all of those sorts of things particularly would factor into their decision whether or not to hold public inquest and which way to go with it, particularly if there'd been Supreme Court findings and that sort of thing. And that's under the Act, that they can't reach a finding that is inconsistent with the court, and our proceedings would not commence. Like the death is reported immediately, but they would generally commence the formal inquest after the conclusion of criminal proceeding.
So if there was a historical allegation of abuse and the court found, well, it couldn't find beyond reasonable doubt that a person's guilty, and the coroner years later thinks it was a factor, even if it's a different standard of proof, they cannot, in their conclusion, make a finding inconsistent with that historical court.
I find that they can identify systemic patterns and that sort of thing, but no, that is my understanding under the Act. They can't. They won't make a finding that is. They are unable to make a finding that is inconsistent.
Because the coroner doesn't have to find anything to the criminal standard, do they, ordinarily?
No civil standard.
Yeah.
No, it's probabilities. Yeah.
Okay. It's quite a carve-out.
As I say, our Act is with the Law Reform Institute, with the Law Reform Institute. Of course, there are workplace deaths, those sorts of things which are mandatory.
Thank you.
And in terms of
Section 25 of the Act, sorry, I've just got that up here. And that sets out the procedure where a person has been charged with an offence.
So assuming that we haven't got to the stage of a criminal case, so that's not there, how, and this might again fall into your coroner's issue, how would you work, or what do you think the main barriers are in terms of interpreting suicidal threats as either coercive control or genuine?
That's really hard for me to answer because I'm not a coroner, and unfortunately I can't speak for a coroner, and I'm not really here in a legal capacity. So That's a really tricky one for me to answer. I'm sorry.
Okay. And in the Act, does it actually have standards of what the coroners are and are? And I recognise that you're under review, but do you actually have standards of what they do or do not take into consideration, or how they should deal with this? Or is that a training thing, or is that a...
Well, Section 28 goes into what a coroner investigating a death must find. Obviously, it's the identity of the deceased, how the death occurred, the cause of the death, when and where the death occurred, the particulars needed to register the death under the birth, death, and marriage registration, and of course, they must, whenever appropriate, make recommendation with respect to the ways of preventing further deaths and on any other matter the coroner considers appropriate. And then that sort of section goes on. They may comment on any matter connected with the death, including public health or safety of the administration of justice. A coroner must not include in a finding or comment any statement that a person is or may be guilty of an offence. And this, the section sort of goes on. So they've got pretty broad powers,
And so a lot of this seems to rely on a level of judgment by the coroners. Is there ongoing training, CPD, that sort of thing?
Yes,
for
absolutely.
The
as I
coroners?
mentioned, they have got a conference that's Tasmania is hosting this year, and they do very, very regular training and professional development at those conferences. Absolutely.
And that would cover things like, changes in family domestic violence law, changes in our understanding, well, for instance, coercive control until recently was not recognised as a form of domestic violence. Would that sort of thing be included?
I don't attend those conferences, but I can seek some advice as to what's the types of things. But certainly, I know, professional development training, legislative reform, those sort of things are generally what is discussed. Absolutely.
That'd be very helpful. Thank you. Any other questions from you?
No, I'm okay.
Good.
Yeah.
Any other questions online?
No, thank you, Chair.
I think that's a no.
Thank you, Chair.
Thank you so much. That's been really interesting, and I have to say we were very excited when we actually saw that you had done this body of work, because it's not something that we necessarily see in other areas. So,
It's not something we've ever done. So, thanks particularly to Rooney and the team for the work that they've done. As I say, it's the first time Tasmania's been able to do analysis of this nature. We are a pretty small jurisdiction, so particularly I think it's noted in there some of the stats in relation to the women and that sort of thing have to be, you're dealing with a really small population size, but confident that we're able to continue to do this work.
Terrific. Thank you very much. So I'll just do my little closing notes. Thank you for your attendance today. If you've been asked to provide any additional information or volunteered it, including questions on notice, please forward it to the Secretariat by the Friday, the 8th of May 2026. Please note that responses to questions on notice will be published on the committee's website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you'll have an opportunity to request corrections to any transcription errors. Thank you again, and the committee will now suspend until 11:30 a.m. Thank you very much. Thank you. So I now welcome representatives of Engender Equality to give evidence. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
My name is Claire Johnston. I'm the practice supervisor and a family violence practitioner at Engender Equality.
Thank you.
My name is Lucy Edmonds. I'm the practice manager at Engender Equality.
Lovely, thank you very much. Although you're not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and it has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is also being broadcast. I'm Louise Miller-Frost. I'm the Federal Member for Boothby, so I'm the Chair.
I'm Matthew Gregg, the Federal Member for Deakin from Victoria.
And we have online Ms Whitty.
Hi, I'm Sarah Whitty. I'm Federal Member for Melbourne, and there's a bit of echo on the line.
Okay, we'll see what we can do. Mr Ng.
Hi, it's Gabriel Ng here, the member for Menzies.
All right, do I have anyone else online? No, great. Okay. Did you wish to make a brief opening statement before we start the discussion?
Just a very brief acknowledgement that Engender works across Lutruwita, Tasmania, on the lands of the Palawa Pakana people, and I want to pay my respects to Aboriginal people in Tasmania. And acknowledge that suicide and family and domestic violence disproportionately impacts Aboriginal and Torres Strait Islander people. Yeah.
I think we just had someone else join us online.
Yeah, good day, Chair. Dave Smith.
Lovely. Member for Bean in ACT. All right. Thank you so much for making the time to come here and for putting in your submission. I'll start with a question and then open up the conversation and we'll pass around. So your submission notes fragmentation of victim survivor information across health, justice and social systems. So we've heard from some other government departments and the like about some other areas as well. What kind of reforms to data linkage or information sharing would actually most meaningfully improve visibility of domestic, family and sexual violence in suicide data?
Thank you for that question. So currently the visibility of family and domestic violence within suicide service provision, suicide prevention work and postvention work is quite minimal. So really family and domestic violence services and suicide work is happening in quite siloed ways. So there's a real need to do some work around bringing those two pieces together, which I think specialist services like us, where we, see victim survivors who are experiencing suicidal ideation and distress on a daily basis in our service, have a lot to contribute to that space. So that's really where it has to start, is coming to a greater shared understanding of how these two issues are interacting across both those spaces.
You describe suicidality as often being interpreted by the system as a mental health issue rather than a response to cumulative harm and trauma. And we certainly, in our previous hearings in Victoria, heard a lot of similar comments from some of the lived experience people and the service people. What changes in assessment frameworks or workforce training do you think would best support violence-aware interpretations of suicidality?
Yeah, so first of all, the current ways that we do suicide risk assessment and work around suicidality in a mental health space are really focused on a person's symptoms, some risk factors, some pretty well-known risk factors around suicidality risk, things like exposure to suicide, bereavement, past behaviours. They're very well documented, but the visibility of family and sexual violence, even in those assessments, is really poor, let alone the actual practice. So what facilitates safe disclosure of family and sexual violence and domestic violence in health and mental health spaces. Certainly in our service experience, victim survivors tell us that they are often really worried that if they do disclose that they're experiencing suicidality and family and domestic violence, that will be recorded and documented in a way that could be used against them in other systems or by the person using violence. And we see that come up in the context of family court, for example, where victim survivors might disclose to their mental health professional that they've been dealing with suicidality. That's documented. Perhaps those records are subpoenaed for court, or the mental health professional is asked to provide evidence to the court about that parent's capacity to parent. And there's a real gendered nature to that. So in our experience, mothers in particular who have disclosed suicidality often find that information is brought up in a way to undermine their parenting, while there is often a double standard for men in the context of family court, where their suicidality might be brought up in the context of men taking positive actions to look after their mental health, and that's evidence of them being a good parent. So there's some really strong, enduring gendered ideas in our systems that make it really challenging for people to feel safe to disclose their suicidality and or family violence and have a supportive response to that.
Okay. I guess the flip side of that is we've just heard from the coroner's court here, and one of the challenges they had, and we've heard from others, is that often when they're looking at a death review, the records are vague and they use things like troubled childhood, relationship issues, emotional issues. So So therefore, the relevance of family and domestic violence and sexual violence to a suicide is less visible as a result. So,
Absolutely, and in our submission we highlight that currently in Tasmania there is very little explicit reference to family or domestic violence, which tells us that yes, there's a problem around data collection, but there's potentially issues with how services are doing the work on the ground with people to create enough safety for folks to be disclosing that. How are people documenting that in terms of their case notes, and documenting that as well in a way that helps protect victim survivors and bring accountability and compassion, because people who are using violence also experience suicidality. So how can we be doing that work in a way that holds accountability and compassion all at once? So we've got we have some issues around the actual service delivery, risk assessment, facilitating disclosure, documenting that, and then that flows through to data collection. I know we do data collection in our organisations, and Lucy does all of our reporting and trying to collect data on various issues across our client cohort starts with making sure that practitioners are writing things down. There seems to be issues right across the Do you have anything to add to that?
Yeah, just from a Tasmanian specific context, we're in a unique position where we're the only state or territory without an established family violence risk assessment and management framework. So we don't have that structural support to manage information sharing and collaboration with other organisations like our peers in the specialist sector, but also beyond, like other states and territories have. So that makes it challenging, as you can imagine, on every single level of this process, from that practitioner who receives a disclosure and then has no framework within to share that information. But then for clients as well, because we don't have that framework, there isn't perhaps that assurance that they know where that information is going to go and how it's going to be shared in that sector. So that's something that we really need. I know there's lots of work being done. We're heavily involved in that ourselves. And it isn't explicitly related to suicidality, but it is that overarching framework for information sharing, and we don't have it. So it's a very unique situation we find ourselves in Tasmania.
Okay.
Yeah.
So we had some government departments in, police, health, justice, and I can't remember the other one, earlier, and they were talking about their family, I can't remember what it's called, but
Their coordinating committee.
and the information sharing, and particularly if there's a disclosure to police, or if police go out in the middle of the night, that goes through. So how does that, or how does your work fit with that?
So,
or does it not?
Yeah, our involvement in that space is very little.
Right.
And in Tasmania, really, family violence response is quite often considered to be the criminal justice response.
Yeah.
We would love to do more work in a crisis area. We would like to expand our service so we can support victim survivors across their full journey of what it looks like to be experiencing family violence, but we're really quite limited, and so we do rely on the Department of Health Family Violence Counselling Service and police response to be doing that acute response stuff, but currently we have no formal information sharing channels with them.
Right.
Yeah, without that framework.
Without that framework.
Okay. Which is a real missed opportunity, especially for the link between suicide and family violence, because as we've noted in our submission, and Claire's said as well, the presentation is often, yes, sometimes it is acute, but it is that ongoing chronic experience, and that's what we see as a specialist service who works with people over a long-term period. But yeah, without those channels to share that information and feed that back to the people in the sector who are resourced to respond, there is that real gap and that missed opportunity.
Okay.
In Tasmania, under our current information sharing, part of the legislation that we have, people are also prescribed people are mandated to share with police, and not every victim survivor wants a police response. So there's also a real gap in creating choice and upholding autonomy for victim survivors to decide how they want to have an emergency response.
And do you have any sense of how often your service or similar services would be the first disclosure for somebody, as opposed to somebody who's bounced around? Maybe a police has been their first contact, or health.
Every week we do intakes with victim survivors who are really just people calling us saying there is something not right in my relationship and I'm not quite sure what it is, but it feels bad. And they desperately want to talk to someone about what that looks like. And when our intake worker unpacks a little bit about what the dynamic of that is, it's really clear that there's dynamics of coercive control or family violence happening, and that person isn't ready yet to want to engage with police about that. They really just want to kind of explore that. We do also have people contacting us who have, been experiencing psychological and suicidal distress, and they haven't connected the dots yet between what's been happening in their relationship. They just feel trapped. They feel overwhelmed. They don't know what to do.
The systemic challenge that comes with that, like Claire said, is often those disclosures happen at the point of intake. Currently, with our resourcing, from that point of intake, in the south, it's a 2-year wait list to then engage with a family violence practitioner for that ongoing support. So again, there's that gap. We're just not resourced to then initiate that response that people need in that moment. We're trialling a few things in our service, but in terms of resourcing, there's a significant gap there.
And so do you refer them to online resources, or like what do you do with people for 2 years?
Yeah, we refer them to the Department of Health Family Violence Counselling and Support Service. We might refer them, you know, if they're disclosing significant psychological distress and challenges, we'd refer them to their GP for a mental health care plan, but there's no guarantee that the mental health clinician will have a family violence lens to support them with the dynamics in their relationship. We'll refer them to other community services like Safe Choices in Tasmania, who do case management support around leaving, exiting violent relationships. So we do as much as we can at that point of intake to provide some kind of service. We offer groups. We occasionally will have capacity in a brief intervention program, but at the moment that program's been closed because we don't have enough staff to keep it open.
Okay. And do you working with 1800 Respect? Do they refer people to you?
Yeah, we commonly have referrals in and out to 1800 Respect, and they're also a service who, if we're working with a client who's experiencing suicidality, they might be one service that we would include in their safety planning.
Cool. Okay.
Yeah.
I'll do one more question, then I'll hand over. Your submission discusses a lack of public discourse about men's distress at the point of separation. How do you think the systems, or how might they better engage with this issue without unintentionally sort of centering and excusing perpetrator behaviour?
Yeah, thanks for raising that. I actually have brought along a case study to talk about from a client who's given us consent. Is that allowed to...
Can we do that without names? Or do you want...
There won't be any names shared.
Names?
Avoid identifying detail.
If you can avoid any identifying details.
Sure.
But yeah, thank you.
Yeah,
Otherwise we have to go into in camera. Which,
of course. Look, this case study is based around an experience of a person who experienced prolonged family violence and coercive control in her marriage, including experiences of sexual assault, non-fatal strangulation, and really insidious coercive control, where she would experience punishments like being locked up away from her children. Really horrific. When police would be called to incidents, her husband's behaviour would suddenly change and he would say that he was suicidal. And so the police response would then focus on his safety and getting him to the hospital. And on multiple occasions, when there would be like health interventions for him, safety planning would then include her as his primary person involved in supporting his safety plan. So there's multiple systems engaging with family violence where family violence isn't being identified, and the response to his distress, whether that be real or manipulative, it actually doesn't matter, isn't thinking about how his behaviour might be impacting on his family and yes, there should be a safety plan done with him, and it should be done with compassion, and it should be making space for any distress that he might be experiencing. But it should be thinking about him in the context of his family and the safety and well-being of his partner and his children.
And in this situation, was it known to, I presume, police or authorities that he was a perpetrator?
She had attempted to disclose, but wasn't having a supportive response. And unfortunately that is an experience we hear far too often. So when there is separation, we see behaviours by people using violence escalate, and I have no doubt that behind those behaviours is real distress. But ultimately what we see is that those behaviours become about regaining control over their former partner, and whether or not they're experiencing suicidality, those behaviours come out as a way to try and reassert that control, rather than taking responsibility for that behaviour, perhaps seeking support around managing that behaviour, seeking support from friends and family that isn't the partner who's just separated. Yeah.
Thank you. I have got two people who want questions online, but I'll go to Mr. Grigg since you're here.
Thank you, Chair. In terms of, I guess, pulling together a coordinated response, it seems that here in Tasmania there needs to be formal reporting well beyond disclosure or anything like that. Do you think that that kind of model offers any kind of template or opportunity that could be expanded to those who disclose if they wish to and things like that, where you get kind of multiple people in the room to help coordinate a response and consider different things like immediate safety needs, mental health, and all those things at an earlier point? And if so, what would be that point?
That's a great question. I mean, there's disclosures happening right at the point of GPs, and I'm thinking about like nurses, like perinatal nurses and whatnot, chaps. And yeah, I think there could absolutely be a place for more collaborative responses to that, which involves specialist services. I don't know if we can have a model that is like, okay, so now the information sharing must include specialist services, child safety, police. Like maybe there is scenarios where that kind of mandated information sharing would be helpful. But at that early intervention stage, you know, it could be that kind of coordinated information sharing happens with a specialist service and the health professional involved, and if there's a children's service involved. So it's sort of at that level, and then depending on what that person wants, it's then kind of expanded following a particular model, or using, you know, in Tasmania we've been trialling a risk assessment tool called a TARA, like using a tool like that can sort of package up some information that then can be shared along the chain depending on what feels appropriate.
I think talking about any form of collaboration like that and information sharing, there is a need for it to have really robust principles that are centred around the victim survivor and what they need, because what we want to avoid is creating systems that are designed to support and offer that early intervention support, but actually further entrench the systemic abuse that then mimics some of that perpetrator behaviour of control. So that's just another
I guess it's creating opportunities, not obligations as well on individuals.
Yeah, that's a perfect way to...
So when it comes to referrals, obviously there's the type of referral where you're just telling the client to go somewhere, or a referral where you're, you know, writing a brief to provide to another professional. When you say referrals to these other agencies, you know, because of the demand, is it just you're informing the client where they may wish to go, or are you able to communicate directly with that second service provider?
It depends. So we would offer the client whatever they need. Would they like us to support them with that referral by filling out a referral form for them? We do that quite, or you know, writing an email to another community specialist organisation who we work quite closely with. Like that will happen quite a lot in our service. For somewhere like 1-800-RESPECT, that is more like a giving of information about how to contact that service. Okay. So it really depends on what that particular service offers. If they have an intake, 1-800-RESPECT, you just call them. They don't have a particular kind of intake or information sharing process that we would follow. But another service like Safe Choices, we would absolutely kind of, with the client's consent, share that information. And sometimes our clients just want to contact those services on their own. So it's really based around what that person would want us to do.
So do you get any follow-up information, even in aggregate, as to where these referrals end up, or what the end point is?
Sometimes, if we have consent from our client to continue hearing about what's happened with that referral, we will get follow-up. Other times, we won't. So
do you get general data, like, you know, you referred 300 people to us, of those 300 we were able to assist these people in this way, that people in that way, so you can be assured that those referrals are a worthwhile endeavour?
Not that specific. I think that does speak to an issue, especially in the non-for-profit sector, is how we're resourced to do the data collection and sharing. If someone came to us and said, can we have that, I would panic, because we don't have the capacity or the resources or the funding to have such a in-depth data collection and sharing system. It would be great. We would love to get that data and share that data, but it's just not something we can prioritise with our resourcing at the moment.
That's understandable. My next kind of question is a bit morbid. So when a person has passed away, do you have much experience of the Coroner's Court contacting your organisation for files and reports?
In my whole time of working at Engender, I haven't had that experience.
Okay.
Yeah. Yeah, and I have had clients whose partners have suicided, and yeah, I haven't had any contact.
Would it be fair to assume that your database isn't connected with the Australian Death Check? So you get notified when someone you've provided services for has died?
I don't believe so.
No? Okay. Right, that's interesting. Is there, in terms of, you've mentioned that there are sometimes diverse experiences of LGBTIQ communities and sometimes men's and things like that. Given the size of the state, I understand that it's very difficult to have specialised services for every group. But is there a kind of an obvious service gap from your perspective where there does need to be a more specialist arm, like for young people experiencing family violence or LGBTIQ people, or is it just necessary for you to have a more nuanced service model?
It's both. So we do have an LGBTIQA plus family violence service, which we run in partnership with Working It Out, and that's been incredibly successful. From my perspective, there's obviously a lot of work to do in that space because we know that gender diverse folk and trans folk have really, really high rates of suicidality, and I think that cohort really it tells us that we need to be looking more comprehensively about how suicide risk and family violence risk kind of work together. Are we assessing for lethality of family violence? Are we also assessing for the risk that someone might suicide because of their experience of family violence? So yeah, that space, you know, that work's emerging. Like I'm not aware of, pardon me, of anyone who's doing that work in the LGBTIQA plus space on those intersections. I mean, I think in Tasmania, the other space, which I can't speak very well for because it's not my space, but I offer it in solidarity. Is, you know, Tasmanian Aboriginal folk have wonderful health services and run organisations, and yeah, I think there's absolutely space to be supporting collaborations between specialist services in those spaces. I mean, we already have some collaborations with the TAS and Circular Head up in the northwest, but that's absolutely another space that deserves greater focus.
Oh, thank you. And my final question, and it's a complicated area, so I apologise in advance. Family law. There's a kind of a lot of challenges associated with that, and intersection between some of these people's experience in the family law system. Are there any kind of major issues you've identified, just current problems that arise out of the family court system and the subpoenas or the like? Any aspect of the family law you wish you could change to reduce risk in this space?
It's a massive question.
I know. I'm sorry.
You can take it on.
You can take it on notice. Yeah.
Give us a submission if that helps. So.
Yeah.
Well, you mentioned subpoenas, and I'm aware that's been in the media recently in this sector, which has been interesting for us to review because yes, it is a problem. And we have really robust processes at Engender, but at the end of the day, if you're subpoenaed, there is so many limitations with how you can object to that. And yeah, what we don't want to see as a result of that process is victim survivors self-selecting to not seek support and not disclose suicidality as something they need support with because they're aware that the person using violence against them might get access to that through the courts and be able to manipulate it to, you know, get custody of the children, for example. So yes, that is definitely one, but also understand it's a complex problem. We just would, as a specialist sector, like a seat at the table if there's any reviews being, you know, happening in that space to add that perspective. Is there anything more from a practice lens?
Or when there's evidence in a family court context, does that go the other way to referrals to services?
Yeah, true.
Yeah.
I mean, I would just add, Engender recently has done some work on this, in this space about naming systems abuse and systems harm, and systems abuse being what Lucy talked about in terms of people using violence, gaining access to victim survivors' information to then use that information against them via a system like family court to undermine their capacity as a parent. Systems harm is when a system itself has procedures and processes and whatnot that actually do harm to someone. At the moment, family court processes take a really, really, really long time. And the harm that it causes for victim survivors going through that process where they're constantly feeling like they are having to be on trial, essentially, to defend their experience of family violence as something that is a valid reason to want restrictions around their former partner's access to children, because of really valid concerns about safety. The impact of that on their mental health and well-being is profound. So, yeah, I mean, looking at systems harm as like how does the way the system is functioning further harm and victimise somebody, I think is worthwhile. And looking at how does that increase suicide risk is worthwhile, and how does that intersect them with fear around disclosing that to services because of systems abuse. Yeah, that's what I would add to that.
Well, thank you very much.
No worries.
Ms Whitty.
Thank you. Matt just asked a lot of the questions, similar sort of questions as I was going to refer to, but you mentioned in your comments before about information sharing and the lack of it. I'm wondering, due to your limited capacity, if you could give me a little bit of an understanding about what you can do in terms of that framework of reporting and communication, if there's anything that we can consider to help with that.
I'm thinking about experiences where things have gone well. So in Hobart, we have a centre called the Phoenix Centre, which provides, if you're suicidal, you can just walk in and you can be met with a peer worker.
Sorry, the Peacock Centre.
Sorry, the Peacock Centre, my apologies, not the Phoenix Centre, the Peacock Centre. The Phoenix Centre is another service. The Peacock Centre, where you can just walk in and be met with support. And many of our clients have found that to be incredibly helpful. And when we've set up, informed consent and information sharing with the Peacock Centre, that's been really great for us to get a sense of how that person has been supported through a mental health crisis, and then return and engage in our service. So there are little sites of promising practice where just based on worker relationships between services are facilitating really, really good practice, and also facilitating client trust in different services. So, we can talk about systems and what kinds of systems can we build, but those systems also have to really ensure that there's space for relationship building between actual workers doing the work with people, where there can be opportunity for checking in about consent to share information. And with family violence and suicide, it's not just, oh yes, I've got your consent, that's the end of the conversation. It's, okay, you want me to share this information, but not this information. And yeah, it's an ongoing piece. So I don't know if that answers your question, but it could be hard to write down all of the, a really clear process when some of it's quite nuanced and relational based.
And I will add to that, that's a good example with the Peacock Centre, because it involves a service that we could share information with and could provide an immediate and effective response, because that's their resource to do so. Information sharing will be redundant if we've all got 2-year wait lists and we're just sharing the information for people to sit on 2-year wait lists, which is often what it looks like. And often the work of our intake practitioner is breaking that news to people that, yes, I can refer you here, but that's another wait list and that's another wait list. So in terms of, yes, we need the systems to better share that information, but then we need those places to be able to actually catch those people and offer that support.
Thank you.
Any other questions from you, Ms.
No
Whitty?
further question.
No, thank you.
No, that's all. Thank you, Chair.
Thank you, Chair, and thank you, Ms Johnson and Ms Edmonds, for making the time to give evidence today. I'm sorry I can't be there in person, Yeah, I noticed in your submission that you have identified some of the periods where somebody might be at greatest risk of suicidality. Really appreciate those insights. It's not something that everyone giving evidence has been able to provide an insight into. I'm wondering what your experiences are currently of those high risk times and how you're informed of some of those things that might arise, such as somebody's released from custody, or when a particular family court hearing might be happening that could raise the risk, how you're informed of them at the moment, and how information sharing could be improved to help you manage some of those risks.
Thank you. Yeah, so currently in practice, what we look for in terms of elevated risk is a sudden change to someone's circumstances that could lead to feelings of feeling entrapped and having lack of choice, or feeling like they can't do anything around improving their safety. So a perpetrator's release is a great example of that, because if somebody isn't informed, if a victim survivor isn't informed about when that's happening, what maybe conditions there are around that release, their capacity to safety plan around that is really impacted. And at the moment, it's hard. It's hard with information sharing from justice to victim survivors. Sometimes it's working, but sometimes it isn't working. Some of those times where it isn't working is where perpetrators might be incarcerated for offences that are not specifically related to the victim survivor. So they might be incarcerated for other offences, drug-related or family violence offences against another partner. And so that their release doesn't necessarily trigger information sharing with that victim survivor about that person being in the community. And so we do see that have significant impacts on psychological health, well-being, and in cases suicidal distress. Another one that we commonly see is an increase in suicidal distress following removal of children through child safety processes. So when working with I work with practitioners as an internal supervisor. Practitioners will be bringing to me clients where they're concerned that there's something coming up, and we'll talk about what could that trigger in terms of the client's distress rising, what could we do to intervene earlier, etc. So it's that intersection between family violence risk and how that's working with systems, I suppose.
And in terms of that information sharing, that's why it's crucial that specialist family violence services who do provide that longer term support throughout all those changes in that person's life that could have the increased risk of suicidality, it's really important we're recognised as a crucial party in that information sharing and not left out of that, because it's that where our practitioners are the people that are most likely going to get that disclosure through that continuity of care and that trust and that rapport that we've built. Not to be left out as like, oh, that's just the counsellor, they're doing their work over there. Like, we're a crucial part of that network.
And that information sharing could trigger the practitioner to then directly ask about suicide, which is best practice for interventions around suicidality, asking directly to the client, this is coming up, I could imagine that this would be really, really distressing. Some people might be thinking about suicide in this context. Have you been thinking about suicide?
Thank you. And I suppose just to expand on the response side of things, so in addition to asking about more directly about suicide to manage that risk, are there, in an ideal world, other steps that are taken or you could take to help manage that risk? And not just you, but other services as well?
Yeah, absolutely. I actually brought along our practice guide. Just give me a moment. Just open up to what our practice guidance is. So, yeah, we've just covered off on recognising any signs or risk factors, which also I'll note here as well, many victim survivors have past experience of gender-based violence, also experiences of childhood trauma, including childhood sexual violence and sexual abuse. So these experiences can often lead to complex trauma, and for some people with complex trauma, that can mean that there's some form of chronic suicidal ideation. So those experiences may not be triggered alone by these kinds of experiences. It might be triggered by shame or other kind of psychological experiences that are triggered by interactions or relationship breakdowns. So it's important that we hold that trauma lens as well on our practice. We would want our practitioners to be really ensuring that responses are also grounded in a trauma-informed practice that is about relational safety. So yes, we can do risk assessment where we're asking that direct question. We might be following up with some other questions about exploring if somebody has been thinking about any plans or intent, but we would really want practitioners to be doing that in a way that is upholding relational safety, providing empathy and care and understanding. For some people, providing, validating and normalising comments that they really are trapped and feeling like there's no other option. And so, yeah, we would want our clients to feel like our response to their suicidality is compassionate and isn't going to kind of categorise them at a certain level of risk and then refer them out if they're too hard. We would want them to feel like we would hold them through a response that respects their autonomy and supports them to safety.
Thank you. That's all the questions from me.
Thank you. We've just got a couple of minutes left, and this is slightly off to one side, but in South Australia we have law which is colloquially known as Clare's Law, where you can actually go in if you have a new partner that you have some concerns about, and the police and a counsellor will tell you if that person has a background in violence that they're aware of. Does that exist here or any similar?
No,
not that we're aware of.
Okay, it came out of somewhere in England, and it was basically a perpetrator who had gone on to perpetrate against a number of different partners and then ended with a murder. And so we have that in South Australia. Anyway, thank you for that.
Is that just, sorry, could I ask, is that just data that the police would have in their system, or is it broader than that? Is it specialist services as well?
Look, I can't remember. It's a little while since I've worked in the sector, so it was certainly involved. It certainly involved police, and it involved like call-outs as well as actual convictions. And it was done in the context of a family domestic violence counsellor there to help the person through whatever was or was not going to be disclosed. So, and link in with services if needed.
Interesting. We'll have a look.
Yeah. I can link you up with Women's Safety Services in South Australia. Would be able to give you more information.
Thank you.
Thank you. Thank you. All right. So, thank you for your attendance today. If you've been asked to provide any additional information, including questions on notice, I can't remember if we did or if you offered anything, please forward it to the Secretariat by Friday, 8th of May 2026, or if you think of something else you'd like to send, feel free. Please note that responses to questions on notice will be published on the committee's website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice, and you'll also have the opportunity to correct or request corrections to any transcription errors. So thank you very much for coming along today, and thank you for your work in the sector. So, thanks. Now, are you Laurel House? Oh, fantastic. Come on down. David Smith going? Thank you so much. So I now welcome representatives of Laurel House to give evidence. For the Hansard record, would you please state your full names and the capacity in which you appear before the committee?
I'm Catherine Fordyce and I'm the CEO of Laurel House, which is actually officially the North and North West Tasmania Sexual Assault Support Services.
Right, lovely. Thank you very much.
I'm Caitlin Graham and I'm the Community Education and Advocacy Manager.
Terrific, thank you. Although you are not required to give evidence under oath, this hearing is a legal proceeding of the Parliament. It has the same standing as proceedings of the House. The giving of false or misleading information is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast, so you know. Do you wish to make a brief opening statement before we proceed to discussion?
Yes, please.
Thank you.
I too would like to start by acknowledging that we meet on the stolen lands of the Palawa people and pay my respects to their elders past and present, and particularly acknowledge the ongoing impacts of colonisation and the disproportionate impacts of sexual violence experienced by Aboriginal and Torres Strait Islander people, often at the hands of white men. I also want to thank you for the opportunity to appear today. At present, family, domestic and sexual violence services and mental health services and suicide prevention systems are largely funded and structured in silos. While both systems are working towards reducing harm and improving wellbeing, they are not consistently designed or resourced to work together in a coordinated way. This separation results in significant missed opportunities, particularly in recognising and responding to suicide risk. For many people, suicidality does not emerge in isolation as a mental health issue. It's shaped by lived experiences of violence, trauma, coercive control, and the systems that they encounter in response to that harm. Preventing family, domestic and sexual violence is therefore fundamentally suicide prevention, and equally responding well, early, safely, and in a trauma-informed way is a critical part of suicide prevention. This is particularly true for sexual violence. Sexual violence, including child sexual abuse, is significantly underreported and often under-recognised within both mental health and suicide prevention systems. As a result, we do not have accurate or complete data on the relationship between suicide and lived experience of sexual violence. Many individuals never disclose or disclose only within specialist services, meaning their experiences are not captured in the broader system data, including coronial processes. This creates a critical gap because what is not measured is not well understood, and what is not well understood is not well responded to. Despite this, specialist sexual violence services are consistently supporting individuals experiencing suicidality directly linked to their experiences of harm, of sexual harm, and to their experiences of the systems that condone and enable violence. These services are often the first point of disclosure, the long-term support system, and in many cases, the only consistent service engaged. However, they are not fully embedded within the mental health system and the suicide prevention strategies, and are not always recognised or resourced as part of the suicide prevention system. The result is that opportunities for early intervention are missed, risk is often only responded to at crisis point, and the underlying drivers of suicidality, including sexual violence and child sexual abuse, can remain invisible within the system. If we're serious about reducing suicide, we need to move beyond siloed approaches and recognise the role of both sexual violence and recognise both the role of sexual violence as a key driver and the role of specialist services in responding to it. Without that, we continue to underestimate the problem and miss opportunities to prevent it. Thank you.
I should also note that we have Ms Whitty and Ms Ng online, so just so you know. We have lost Mr Smith. He had another event to go to, so he's dropped off. Referring back to your submission, you highlight that perpetrator suicide can cause long-term harm for victim survivors and actually be themselves a trigger to suicidality. What mechanisms do you think could support survivors when justice pathways sort of collapse?
I guess we see all too often the experience of the commencement of a justice response to child sexual abuse or sexual violence in that, you know, police start proceedings or start investigating, and at that point we see significant concerns about the perpetrator's mental health, and all too often we see suicide happening during that kind of process, and we see the very significant and cascading impacts that has on victim survivors and their extended families, particularly in contexts where it's interfamilial child sexual abuse. We have given examples around and have many examples that we could, too many sadly to count, where that experience of a disclosure from a young person has then led to the suicide, well, not directly, but the disclosure of the event, of the experience of child sexual abuse, the subsequent investigation, and then a suicide within that family, that perpetrator, and the cascading kind of impacts that then has on their relationships, the blame that they feel, even though they are absolutely not to blame for the behaviour of the person that was harming them. I guess through that process, you know, for many victim survivors, there's an element of control is taken from them as soon as, particularly if they're children and young people, that they've disclosed, and then a police process kind of starts around them. And that it's done so in an environment where we have a lack of understanding in our community of the dynamics at play in relation to child sexual abuse. And so we too often are blaming in our community victim survivors and not pointing the attention to where it lays, the choice of a perpetrator to use behaviours to abuse and to be violent towards a victim survivor. And so I think that some of the scaffolding that we're putting around at that point for the broader family, the understanding of the dynamics of child sexual abuse is not strong enough to both keep the victim safe in that process, but also ensure that the perpetrator has minimal experience, you know, minimum means, but also the support to prevent suicide in those instances. Katie, did you want to add?
Yeah, I suppose the other thing that does come up semi-frequently is when there has been an experience that has resulted in a perpetrator dying by suicide, what we don't often see is consistent flows of communication back to victim survivors, whether they're victim survivors who have made initial complaints or who might have not necessarily gone down a formal pathway but are considering it and may have reached out for their options. So that then creates further harm for them if they're finding out in a way that isn't necessarily a supportive way and doesn't then give them the options that they need for the next steps to understand what they can then do.
And we understand that in a number of cases that that kind of news has come to some victim survivors via the media, for example, and so that can be a really catastrophic kind of outcome for a young person or for an adult victim survivor of child sexual abuse to be opening the paper and seeing a picture unexpectedly of your perpetrator who happens to have suicided, and the kind of cascading sequelae that results in.
Yeah. Okay, thank you. You also note that sexual violence services are rarely contacted by coronial investigators, and this is, you know, really the crux of our terms of reference is really that link between family, domestic and sexual violence and suicide. In terms of how this might work better, had you got any thoughts about how you would be able to do that in a way that doesn't compromise clients' privacy? And I'm also interested in, you know, often when we're talking about particularly child sexual abuse, the disclosure period is a long time, or can be a long time afterwards. And how do you think that would work in with the coronial processes? Keep in mind you're not coroners, I accept that.
I guess there's a couple of things. I think that, I mean, the very fact that this hearing is happening where you're looking into this matter has got us as an organisation thinking more about the fact of, well, why haven't we been contacted by coroners previously when clearly either victim survivors of suicided or perpetrators of child sexual abuse or sexual violence and known perpetrators why haven't we received requests for information? I guess I'm really hopeful that, you know, starting this conversation means we can have a more open dialogue about how do we collect that data in a way that is useful to a coroner, but also how do we design the data systems in ways that protect a victim survivor's agency in relation to, you know, maybe what they would be open to having shared, you know, the sanctity of that kind of clinic room, the counselling session, and what's appropriate or otherwise to share. I think we would want to do some really careful work and really careful consideration, particularly where there is intrafamilial abuse and the disclosures within a counselling space may be really complex in terms of having cascading impacts on other family members, other victim survivors. I think for us, I echo the comments of our colleagues at Engender Equality in that we really don't have sufficient or strong investment in our data systems by our funders that would enable us to really scrutinise our data in ways both to answer the questions about risk of suicidality when we look at our data overall, or particular ways that we could extract data that would be useful in relation to an individual client or groups or cohorts of clients. So I think some thinking and some capacity building, both of our sector and of our colleague sectors in how they collect data in relation to child sexual abuse and sexual violence experiences would be really advantageous, and some genuine co-design work in terms of how we might do that and how we might be able to work more effectively with the Tasmanian coroners, so that we can actually kind of have some meaningful dialogue that informs meaningful change.
Thank you. Mr. Greg.
Thank you. It goes on a similar theme around data collection. How often do you think that the only record of a disclosure would be found in organisations such as yours, and probably not in the hospital records, the police records?
I would say it's pretty often. So there would be a small proportion of our clients who will have come to our attention through a forensic medical examination, and as such, a forensic medical examination is the Department of Health conduct the forensic medical examination, but our team are there as a support to the victim and their family, their support people through that process, kind of being advocates and supporters. So in those instances where a forensic medical examination has occurred, there would definitely be a health record. I guess if the victim survivor we were supporting presented at an Arch centre where they also reported to police or to one of the other services in that multidisciplinary centre, then that would obviously, but those two cohorts are a very small proportion comparatively of all of the other victim survivors that we would serve. Similarly, children, we would have made a notification in relation to any child that has come, so anyone under 18. So again, those victim survivors, there would be a record of their involvement with us and a disclosure. So it probably is the adult victim survivors who it's been a long time that they never, at the point of the experience of abuse, had a forensic, they didn't disclose in childhood, that they're not yet ready or might never be ready to navigate a police process. And that includes both victims of child sexual abuse or sexual violence within the context of family violence, or other forms of sexual violence that might be through dating apps or through contact with strangers or kind of peers or colleagues or the like. So without giving you a proportion, I guess it gives you a sense of that there's still a large number of clients that we're victim survivors that we're serving where that we might be the only place they're talking about their experience of sexual violence. It doesn't mean they're not engaged with other services, and I think that in some instances they may have been open with GPs or with other allied health professionals, mental health services, but in many other cases they, are not seeing those places as safe to talk about their experience of sexual violence.
So would it be correct to say you're not, so I've asked this of other providers as well, so I assume you're not connected to the Australian Death Check, don't get notification that a past client has died, and then the authorities don't get a notification that deceased person may have used your service, is that?
Until you mentioned it a moment ago with the Engender team, and until you've mentioned it again now, I've never heard of the Australian Death Check.
Okay.
So no. My colleague Katie might have.
Also had not heard of it, no.
Okay.
Yeah.
And Katie's had a past experience working in
suicide prevention. So.
Okay.
Yeah.
Yeah.
That's very interesting. In terms of mandatory reporting, so if a victim of family violence tells their story, and as part of that story it becomes evident that a child may be subject to abuse as well, does that trigger mandatory reporting even if it's in the context of that confidential relationship?
At Laurel House, absolutely.
So whenever there's a risk to a child, report automatically?
Yeah.
Has the segregation of that kind of child protection service, family violence service in general in Tasmania, and I've noticed you've got a strangely narrow definition of family violence here,
Yes, strangely narrow.
Would one kind of triage and support regime that kind of covers the lot be more optimal, or can you think of another jurisdiction where the system appears to work a bit better than it does here?
I think I might like to take that
That's
on
fine,
notice. Yeah. That would be useful. I guess my kind of initial thoughts are that mandatory reporting has at times some real challenges, and so thinking about expanding mandatory reporting beyond children and young people raises some significant concerns to me, and I know that I have colleagues in the Northern Territory working in the sexual violence sector where there are much more stringent mandatory reporting requirements in relation to family violence, and also working with colleagues in the state service down here where they are much more kind of mandated to act in relation to family violence than we as the community sector are. There's some very significant concerns that we would have around people seeking the support they need if seeking the support they need immediately triggers a report to whomever that might be. I certainly really clearly remember a conversation with a group of young people about their knowledge of the mandatory reporting system and what they do and don't say in counselling in order to avoid mandatory reporting. And, that just bothers me so much about the fact that, kids are young people are sitting in counselling sessions holding on to key bits of information that might be really important to support their healing and recovery journey because they're worried that by saying that thing, that will have a cascading impact on where they're living, where their siblings are living, their connection to their family, their connection to kin. So I guess my immediate worry about expanding anything is what does that mean in terms of service access and then healing and recovery, but also the potential for much more kind of problematic outcomes for victim survivors.
Would you extend that to even proposals for more information sharing between organisations? It sounds like that trust and sense of confidentiality is really valued by your clients, and if they believe that there'd be a whole bunch of other people they don't know having sight of that information, that could also have a similar effect on limiting disclosures.
Absolutely. And I think we were really careful I'm not sure if you've been we shared a little bit in our submission about the Arch Centres. So the Arch Centres are co-located police, Laurel House in the North and Northwest Service, and our colleague organisation SAS here in Hobart, the Family Violence Counselling Support Service, and Child Safety, the Advice and Referral Line. And we were really clear through our consultation early on with our staff and with victim survivors about being co-located doesn't mean unfettered information sharing. It means an opportunity for us to work in a way that smooths the fit for victim survivors, that we can run down the hall and grab a police officer to come down and have a chat to a victim survivor, or vice versa. But it doesn't mean that we just hand over holus bolus a client's file, that's done with, careful consideration, with choice, with empowerment, such that the information the victim wants shared is shared, not all information is shared.
My last question, in terms of referring out, one of the difficulties is sometimes you get a disclosure and you've got a referral pathway, but it might be a 3-year waiting list or something like that. Dead ends in the support system, basically. Could you identify what you've identified as really concerning ones of particular areas where you want to be able to help someone, they need this particular kind of support, but you know that no matter what you do, they're not going to get that support in a timely way?
I guess there's probably a couple. So the one that stands out to me, one of the most worrying, and I know that there's work going on in this space, is the pathway to really intensive mental health support for children and young people. So we've got really good relationships with Headspace, but when we're talking about children and young people who would benefit from the more intensive support of a child and youth mental health service, the barriers to engagement, the barriers to delays in services, quite often because of staff shortages and challenges with recruitment and retention in regional and remote parts of the state, is that that we're left holding those clients in our care, even though their supports would be better managed by a more intensive support service. So that probably is one, and which has some cascading impacts on our capacity, because if we're needing to do more wraparound support to keep a child safe, then we're not able to see more clients that would be sitting on our waiting list. Katie?
Yeah, I suppose to add to that, what we see in the mental health sector, which then kind of, like Catherine has said, has the cascading impact on us, is services that are supposed to kind of hold people at the mild to moderate level of care need are holding people at a more severe to acute level of care, which then results in us not being able to refer out in an early intervention and prevention way. So people need to reach that really level of acuity that is quite severe before they're able to then enter the system, which then kind of creates this ongoing snowball of everyone needs to kind of be at an acute level. It costs more, it's harder on the system, and no one can then do that prevention work that keeps people well.
Thank you.
Thank you. Mr. Ng.
Thank you, Chair, and thank you, Ms. Fortis and Ms. Graham. It's Gabriel Ng here from the member for Menzies from Melbourne's East. Are you able to hear me? Hello?
Yes. Can you hear us?
Yes, I can hear you. Thank you. Your submission states that sexual violence, in particular childhood sex abuse, should be treated as its own major driver of suicide risk and not just folded into the broader DFSB category. Would you be able to expand, please, on why you think this is important?
I guess what we see a lot is that suicidality is treated in a really clinical way. However, there are so many different contributors to someone being in a state of suicidal ideation that are outside of a clinical need. They are social, emotional, environmental circumstances that result in someone having suicidal ideation that don't necessarily require a clinical response. And so particularly when it comes to child sexual abuse and sexual violence, there is nothing clinically that has contributed to that individual being in the circumstances that they are and the experiences that they've had. However, what they are then experiencing is a clinical response to potential non-clinical contributors, which is why it's really important for it to be considered in a nuanced way around what are the needs and the drivers behind someone's suicidal ideation, rather than how are we going to respond clinically to this individual.
And I think one of the colleague organisation on the mainland, Sexual Assault Services Victoria, did a report where they interviewed a range of victim survivors, and they identified that many victim survivors, in navigating the mental health system as their first port of call, actually kind of experienced harm because of the lack of violence-informed, child sexual abuse-informed practice that they were receiving, such that, you know, this kind of this experience of being kind of medicalised and pathologised, rather than recognising that the response that someone might have is a pretty normal response to something that's abhorrent, and, you know, and being able to kind of come to a specialist sexual violence service that's informed by and understands the social constructs that have led to the experience of violence, and being able to unpack those issues and those kind of constructs, and being able to kind of allow that victim to survivor to see that they don't hold blame, and they shouldn't feel shame in relation to their experience of child sexual abuse, is really, and where you can really unpack the very specific experiences of victim survivors. You know, we often are talking to male victim survivors about their fears of growing up to be perpetrators, or, you know, male survivors who have just had children being worried that they might harm their own children. You know, these are really nuanced experiences and consequences of child sexual abuse that are not necessarily well understood by kind of mainstream, from our perspective, mental health providers or services that are kind of skilled in responding to suicide in other cohorts.
The only other thing to add to that that's just come to mind a little bit is with the clinicalisation of suicidality, particularly when there's a sexual violence or child sexual abuse experience, results in referral pathways, assessment approaches, funding at a systemic level, all being quite clinical in nature, which then misses the specialist care that someone may need to access services or to navigate systems that are otherwise non-clinical justice pathways, etc. as well. So it's both important for the victim survivor to have that specialist service, but it's also important for the system to recognise the role the specialist services play that general mainstream services don't really do.
Thank you. And what are your thoughts as a specialist sexual violence provider on sexual violence being often associated with domestic and family violence?
That is a terrific question, and a point of continued advocacy for our service here in Tasmania, but also other sexual violence services nationally. I think we are progressively seeing a bit of a rolling up of domestic, family and sexual violence services, and I guess our experience as specialist sexual violence services and in the networks that we interact with is that that kind of rolling up hasn't always been associated with change of practice in some domestic and family violence services. I acknowledge that there are others, some here in Tasmania, that have done a terrific job in building their knowledge and capability around responding to sexual violence. And so I guess we're sometimes seeing, and an example of that is the primary health project that was initially piloted just around domestic violence in particular jurisdictions, domestic and family violence, where training was provided, capacity building was provided to GPs around their ability to respond to family and domestic violence. In the second rollout of that, kind of the bumping up of that program into more jurisdictions, sexual violence and child sexual abuse was added to the program, but without any consultation with sexual violence service providers or child sexual abuse providers about whether that particular model of building capability in the GPs would be appropriate for for sexual violence services. And what it also meant was that the existing services that had been running the program that might have been domestic and family violence services in some jurisdictions then were given an expanded remit without necessarily having the long and deep history of sexual violence and child sexual abuse service provision that might bring a more nuanced or a different perspective to how you might do some of that work. And so we're seeing that, I guess, across, and, you know, it is desperately important that we're thinking about the intersection between domestic and family violence and sexual violence and child sexual abuse, that they are interlinked and they have intersecting pathways, but we also need to think about them as distinct, and the experiences of victim survivors of sexual violence and child sexual abuse as what's needed for them, as well as the prevention and early intervention services and systems need to be thought of in both an interrelated and distinct way.
And in terms of services for people who are victims of sexual violence outside the, I suppose, the family setting, the domestic setting, has it meant that there's been insufficient services for them or insufficient focus on people who experience sexual violence in that setting?
Yeah, I guess that is one of the, you know, in the merging of domestic, family and sexual violence at both a kind of national level, when we're thinking about a national plan, you know, the critique of the sexual violence sector is that it's still pretty light on in relation to its efforts in relation to sexual violence. I guess in any kind of forum where we're talking about domestic, family and sexual violence, the sexual violence bit becomes a smaller part of the broader conversation about domestic and family violence. And then the child sexual abuse part is, and so I guess in any kind of response, we see a smaller focus on the sexual violence component, which means that quite often people are not feeling seen in their experience of sexual violence. We know that that happens too when we think about child sexual abuse. We get a lot of attention in relation to institutional child sexual abuse. We had a whole Royal Commission. We've had a whole Commission of Inquiry in Tasmania about institutional child sexual abuse. And while it's abhorrent and we clearly need to act in relation to it, there are many more victims of child sexual abuse outside of institutional settings whose experiences are equally devastating and equally need to be considered. And so I think it is where we group things together, we risk losing the nuance, but we also need to be thinking about those intersections really carefully so that any group is not being misrepresented. And in this case, it might be victim survivors of other forms of sexual violence outside of intimate partner sexual violence.
So I suppose thinking about how services are actually delivered on the ground or how programs might be designed, how do we get that balance right between services, or recognising that intersectionality, but also making sure that there is enough support or enough recognition of sexual violence as a discrete issue?
I think that's a really good question. I think that on the ground, the relationships that exist between specialist sexual violence services and specialist family violence services definitely walk that line really beautifully. You know, quite often a victim survivor might present to Engender Equality initially and get support from them, and down the track they may come over to Laurel House or vice versa. So I think for many victims, because of the experience of re-victimisation, you know, they may have an experience of child sexual abuse and then in later life have an experience of family violence. And so wherever they present to get the specialist support that they need is really critical. So that upskilling of us as a sexual violence service, we need to be, you know, pretty good at responding to domestic and family violence. We're not going to be the specialists that our family violence colleagues might be. The same for our family violence colleagues. They need to be able to respond to child sexual abuse and sexual violence. But I guess that what we're seeing kind of universally across the nation is that services are under-resourced, and that we're under-resourced to build the capacity of each other. We're then under-resourced to build the capability of our mental health colleagues and the broader service system so that they are doing a better job in responding to a disclosure. You know, the best place for someone to disclose and get support is the place that they feel safe and comfortable at. And so I guess the systems need to be working in collaboration and not in competition. If we never have to see a victim survivor because the mainstream system is holding them safely and supporting them and giving them what they need to, you know, heal and recover, then great. Our services, I guess, become most critical when that system needs our support and victim survivors are not getting what they need from the other mainstream services. Katie, do you have anything to add?
Yeah, I suppose the only other thing I have to add is when kind of scanning out and looking at how mental health systems and suicide prevention systems are designed more broadly, when family, domestic and sexual violence is kind of seen as a secondary contributor rather than a primary assessment domain, it results in it not necessarily being identified and looked at in a way it needs to be. And so designing systems on the ground, not just within the capacity of sexual violence and family and domestic violence services, but also within the broader mental health system and the tools that they use to make sure that a whole person is considered rather than specific nuanced domains of need.
I might go to Mr. McCormack now.
Thank you, and I'm sorry I was late to this particular session of this most important teleconference. Can I just ask, I'm a regionally based MP, and I just would like to ask, what special or unique challenges do you face and confront in your role, given the fact that you are also based in rural and regional areas of Tasmania?
That is a terrific question and a point I can't believe I didn't mention already. I guess that we do see really significant impacts of rurality on the lives of victim survivors and on our capacity as services to meet their needs and the capacity of the broader service system. So I guess from the very first point of the experience of victim survivors is that we know that we have much higher rates of domestic, family and sexual violence and child sexual abuse in northern and northwest Tasmania. We also know that there are significant barriers to accessing supports, and that includes, you know, very little public transport, the capacity to get to your local service might be limited. We also know that there's significant digital divide, and so often the kind of first response to regionality is, oh, we'll provide a telehealth response. Well, actually, when you're talking about family, domestic and sexual violence and child sexual abuse, it may not be safe for someone to have a service online. But also then outreach services are really challenging as well in terms of finding places that are safe and discreet enough for people to feel like they can come and access support. And often we have conversations directly with a victim survivor. This is the place we normally come to when we come to your town for outreach. Is that somewhere that you'd be able to come? And quite often we're told, no, my sister-in-law works there, or no, it would be really difficult for me to get to that place. And so there's a lot of kind of direct kind of navigating those things. And, you know, you can't park. If you live in a regional and remote area, as you would know, you know, people know your car. They know all of your cars, probably, if you've got multiple cars. They know the farm ute as well. So being able to get to a place safely to make a disclosure, to access services is incredibly challenging. And I guess we also know the kind of cascading complexities around the links between rurality and fatality in relation to family violence, particularly in the presence of, you know, increased guns and the like. I guess from a service provider's perspective, being able to attract and retain highly skilled people that we need to do the work that we need in massive workforce shortages. You know, my colleagues in capital cities don't understand the challenges that we have and the increased costs that we have in relation to that service provision. We currently have 3 main offices at Laurel House compared to our colleagues in other organisations. So the costs of doing our work across a geographically dispersed community is considerably higher, and that's not recognised in any of the funding streams that we receive from both the state government or the federal government in terms of the complexity of that service delivery. And I guess, with the current fuel costs, those things are not adequately factored into our experience of providing support. It does mean that we often recruit more junior people with less experience. We invest considerably in them and then they move back to the mainland. So it is those kinds of experiences of and we do a lot to provide support so that there's safe and quality services, even if we are employing more junior people in terms of the level of support and supervision. But it is definitely a complex piece. The Tasmanian Commission of Inquiry also spoke to just some of the dynamics of a close-knit community and what does that mean when you disclose, and what's the system response, and this kind of, well, he's a good bloke kind of rhetoric that goes around because, someone might have been the president of the football club. That means he couldn't possibly have been. So the dynamics of a rural community really are at play both for victim survivors and for our service system.
Thank you. That's very compelling evidence, and I really appreciate what you do. Thank you for doing what you do for all the good people in your area. Thank you very, very much.
Thanks so much.
We've just got a few minutes left. So, look, one of the questions that goes to our terms of reference is looking at how you can distinguish between suicidal distress and suicidal behaviour as a form of coercion, a controlling tactic. Is that something that, do you see that as well as in your practice, or are you very much only seeing the victim survivors? And if so, how do you tell the difference?
We're only supporting victim survivors. Yep. However, I guess in the context of, in some instances, the victim survivor may still have considerable contact with the perpetrator. Yep. And so I guess our counsellors would often, be hearing about the conduct, the behaviour of a perpetrator. I'm happy to go back to our team and provide a more fulsome response in relation to that. As separate to that, I guess, because we don't consider children and young people who are using harmful sexual behaviours as perpetrators, we do have a program where we provide support to children and young people who are using violent sexual behaviours towards other children in many instances. And I guess that our team are doing very careful assessments of those children and young people around their needs, but also because the safety planning that goes around them and their use of harmful sexual behaviours may see them being moved away from their family, or might see them moved away from programs, extracurricular activities that they enjoy, their school class, etc. The team is really regularly engaged with the young person, the team around that young person, around risk of suicide, and is a very frequent kind of point of discussion between the team when they're supporting each other around the complexity of those cases. And it is, I guess, a reflection, of the lack of sophistication of our system to identify children and young people early, to prevent behaviour escalating to such a point that the children and young people who are using harmful sexual behaviours might be excluded from their usual support networks. Yep. And it's particularly complex in situations where there is intrafamilial use of harmful sexual behaviours, where a parent is needing to navigate a child using harmful sexual behaviours and the other children in their household, and what does that kind of look like in terms of supporting and securing safety for that young person who might be using harmful sexual behaviours.
Great, thank you. Look, thank you so much for your attendance today. If you've been asked to provide any additional information, including questions on notice, and I think you did take a few things, and please forward it to the Secretariat by Friday, 8th of May 2026. Please note that responses to questions on notice will be published on the committee's website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you'll have an opportunity to request corrections to transcription errors. And thank you very much.
Thank you so much. Thanks for taking the time on such an important issue.
Thank you.
And thank you for submission of comments.
Thank you very much. Now, I'll just go through our required document. I now welcome the representative of the Tasmanian Family and Sexual Violence Alliance to give evidence. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
Bree Clerk, CEO of the Tasmanian Family and Sexual Violence Alliance.
Thank you. Although you are not required to give evidence under oath, this hearing is a legal proceeding of the Parliament and it has the same standing of proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence today will be recorded by Hansard and attracts parliamentary privilege and is also being broadcast live. So I'm Louise Miller-Frost, I'm the member for Boothby, which is Adelaide sort of middle southern suburbs, and I'm the chair of the committee.
Matthew Gregg from Deakin in the outer eastern suburbs of Melbourne.
And online we have Ms Whitty.
Hi, I'm Sarah Whitty. I'm the member for Melbourne.
Mr Smith. Okay, we did have Mr Smith. He is the member for Bean in the ACT. Mr Ng.
Hi, it's Gabriel Ng here, the member for Menzies.
And Mr McCormack.
Hello, it's Michael McCormack, member for Riverina in southwest New South Wales.
Thank you. Did you wish to make a brief opening statement?
Yes, please. Thank you. And thank you for the opportunity to appear today. I'd firstly just like to begin by acknowledging the traditional custodians of the lands on which we each meet today, and also pay my respects to elders past and present, and acknowledge Tasmanian victim survivors of family and sexual violence. I'd also like to note the gravity of the subject matter and the systems that failed to reach those who have died by suicide and the people that are impacted by that. The Tasmanian Family and Sexual Violence Alliance is Tasmania's peak body for family and sexual violence, and we work across the full continuum of primary prevention and through to healing and recovery. And we amplify the voices of lived experience and also practice knowledge to drive systems change. I'd firstly like to also acknowledge the submissions made by some of our members, so Engender Equality and Laurel House here today, and also recognise the Tasmanian Coroner's Court submission and the Tasmanian Government submission. For context, Tasmania has the highest rate of intimate partner violence in Australia, and our age standardised suicide rate is 14.9 per 100,000 population, exceeding the national average of 12. The Tasmanian Suicide Register tells us that violence or abuse was a risk factor in nearly half of all suicides recorded between 2012 and 2018. And this is really significant and requires that systemic response. Also in Tasmania, 933 women return from crisis shelters to a violent household each year, not because they choose to, but because there is nowhere else to go. And housing insecurity is both a driver and a consequence of family violence, and it's also a documented risk factor in suicide. Equally, court delays, trauma-uninformed processes, and the weaponisation of family law proceedings by perpetrators extend and deepen victim-survivor distress. Systems abuse using courts, child contact orders and financial proceedings as tools of ongoing coercive control is one of the most insidious and least recognised drivers of sustained psychological harm. Contact with courts, police and corrections appears as a stressor in 48% of Tasmanian suicides as well. And the cost of living crisis is not separate from this inquiry either. Economic abuse is a primary tactic of coercive control. Financial distress following separation, including loss of income, debt accrued under duress and legal costs, is a shared risk across both family violence and also suicide. For Tasmanians already living with high rates of socio-economic impact, these pressures are compounded. We also have real concerns about service access and what it means for people to wait long periods of time without support to address family violence. In some parts of Tasmania, wait times for specialist DFV services is up to 3 years. These risks are not evenly distributed, and it is the operation of power, control and discrimination that creates the conditions for both increased family violence and increased suicide risk among those already with the greatest barriers. And that includes Aboriginal Tasmanian people that are experiencing family violence at rates far exceeding the national average and face profound barriers to safety in systems shaped by colonisation. The relationship between DFSV and suicide in Aboriginal communities requires a community-led response, adequately resource Aboriginal community-controlled organisations to implement it, and a genuine commitment to self-determination. LGBTIQA plus Tasmanians face rates of family violence, childhood abuse and suicidal ideation that are 2 to 4 times those of the broader population. Between 64% and 91% of LGBTIQA plus Australians have thought about suicide. Stigma, discrimination and services that are not designed for them create compounding barriers that are poorly captured in current data. And children and young people are often too invisible in DFSV frameworks, yet suicide accounts for 32 to 38% of all deaths of young people in Australia. 1 in 2 young people are not just secondary witnesses to adult violence, they're the primary victim survivors in their own right, and our responses must reflect that. To understand the full implications of DFSV and suicide, we need better data. A joined-up, nationally aligned approach with common data collection points, intersectional data capture and coronial records linked to police DFSV histories. We cannot prevent what we cannot see. And we also need health services trained to recognise the relationship between DFSV and suicide. Women and girls are present to health services in significant numbers with intentional self-harm, which is also a documented predictor of suicide. Those presentations are opportunities for intervention, but we need clinicians that connect self-harm to the violence that is potentially driving it. And importantly, we need to prevent DFSV in order to reduce suicide rates. We need adequately funded specialist services, primary prevention investment and the infrastructure to actually reach people in crisis and not optional extras. We needed consistent frameworks that are resourced and implemented locally alongside consistent and sustained political leadership too. So thank you, and I welcome your questions.
Thank you so much, and thank you for coming in. I apologise, my
head
cold is developing nicely today, so
thank you for coming.
That's right, I was fine when I arrived. Look, I have a couple of questions, and then I'll hand over to my colleagues. So, you emphasise the mutually reinforcing relationship between childhood abuse, adult, domestic family, sexual abuse and suicidality. Have you seen good examples of interventions across the lifespan that can actually disrupt this, knowing that, you know, it often is a generational, you know,
the cycle,
reinforcing thing?
Yeah. And I think what is really important is the early intervention response. So if we're looking at children and young people in their family environments, we need to make sure that we're getting in early to support them and addressing that early. Unfortunately, in Tasmania, we're seeing wait lists for child family violence counselling up to 3 years. and that's just really not acceptable, and it impacts on children, young people, and potentially perpetuates that cycle if they're not getting the support that they need early.
Yeah. You note that coroners often rely on a primary family member as the senior next of kin, who may also be the perpetrator, and we've actually heard about that from a number of lived experience and family submitters. Do you have any ideas on alternate evidence gathering processes or ways that a more appropriate person could be identified?
I think considering what other services have been accessed during that time could be a potential way of doing that, and I think it comes into that information sharing process. Of course, there's opportunities to access data through the Safe Families Coordination Unit. They have data around different government services, so potentially accessing that as a starting point would be useful. But also looking more broadly, rather than just the next of kin, maybe there is a standard practice where coroners are looking at other siblings or family relatives that could provide some information as well and context.
We did hear from the various departments of the Tasmanian Government about that information sharing. We've also heard from, I'm not sure how much of you've heard already, but we have heard from some of the not-for-profit sector that they aren't part of that, but also when coroners have been involved, they haven't been contacted either. So, so for a disclosure that's only gone to the sector, it may not be visible.
Yeah, that's it. And I think we've recently conducted a survey for the Family Violence Act review that's being undertaken here in Tassie at the moment. And 51 victim survivors responded to that survey. 58% of them didn't disclose their experiences to police. So there is a potential that we're really missing some gaps there in terms of the data around victim survivors. Yeah.
And I'll just do one more and then I'll pass across. So you argue that first responders, including police, still default to health pathways when perpetrators use suicidal threats as coercive control. Is there a form of training or something that would enable first responders, such as police, to differentiate between genuine suicidality and manipulative, coercive tactics, keeping in mind that it can be both as well?
At the same time,
and are first responders best placed to make those judgments, or
it's a great question.
How else would it happen?
How could this possibly happen? So I guess one of the things in Tasmania is that we have a program called PACER in some parts, it's called Mental Health Emergency Response in other parts of Tassie, and that's a co-response between police and mental health clinicians and Ambulance Tasmania. So when they receive a mental health call, like in suicidality, then that response team is meant to go there. So it's trained specialists with mental health backgrounds, police and ambulance response. So I think in our submission we suggested that perhaps there's opportunities there to bring in that more DFSV specialist response as well, and specialist knowledge within that team to support understanding what that looks like. I think a mental health response, if it's a suicidality, it's probably always going to take precedent. But the gap is, how does a police officer or whoever's attending ensure that there's a family violence order or something in place before that person leaves hospital, or,
And we have heard a fair bit about misattribution of who's the perpetrator and who's the victim as well.
Yes.
Right. Mr. Greg.
I suppose linking to that, there is probably only so much we can realistically expect of a constable in the moment. But, they've identified a suicide risk, there is family violence, I suppose. Is there a next step that person can use that prompts a process that ensures any childhood safety issues are addressed, any spouse that might be directly affected is receiving the support they need? Is that kind of coordination a given or even an opportunity for police?
I believe that in the first instance, not really. So it is just a general duties officer. Often that's the one that's responding to the crisis. There is family violence units within TAS Police that would then be utilised. And we have in Tassie the Safe at Home team, which is a partnership of organisations. But I think in that crisis response, there really needs to be a community focus as well, because often that community information isn't there right at the point in time what they need it to address that misidentification and address all the wraparound supports that are needed within that moment. So I think it's in Northern Territory, maybe Alice Springs, that they do have a co-response police and a family violence specialist team. It might be something I need to have a look at it myself. I think there were a few pilots that were happening. But I think something like that would be useful and beneficial. It would, one, train up police, because they are getting training, but there's only so much training that someone can receive before they go back out and do their work. So if there's more opportunities to collaborate and work together within those crisis responses, the better for it.
How is the relationship between schools and the providers of support services for domestic sexual violence?
I'm not 100% sure. I'd have to take that on notice, but I guess some of our organisations work quite closely within the prevention space within schools and deliver education and training to schools and to students directly as well.
Here in Tasmania, the statistics are particularly distressing. I mean, obviously the increased prevalence and some of that may be linked to more being rural and regional and lower SES. Are we failing to match kind of the service intensity with what we know to be the predictive areas of need and demand?
I think so. I think that hasn't really been thought through as much as it needs to be. I think, often in terms of resourcing, it's a per population based approach. It's not necessarily looking at the demand and the risk factors and then what needs to be channeled into those areas to address and resource appropriately. So I think, a shift in that thinking is really needed.
Have you identified around perpetrators? And obviously we've seen cases where perpetrator suicide has led to kind of a series of events that has increased that cycle of distress and violence and economic vulnerability. Do we have post-suicide supports for families and loved ones? So obviously there's contact with the next of kin, but do we use that as kind of a red flag that then brings in a response to support those around them?
That's a good question. I guess in the suicide prevention space, which used to be my former area of work, similar to Katie, there is support after suicide services. I don't know how well funded or resourced they are. I think they might be national as well. I'd have to double check that. But certainly in terms of risk factors, having a family friend or a friend that's died by suicide increases the risk of suicide itself. So yes, definitely having those supports available to people would be really important.
Can I just jump in? Does that postvention include a recognition that the person may have been a perpetrator and therefore it may be an incredibly complex set of emotions that survivors are feeling?
I never noticed that when I was working in that space. So yeah, that would certainly be of use, I think, to have that extra training and understanding and whether there's links with specialist services to support that understanding as well. I think, that the more joined up that we can be across services and across the sector. So we've got our family violence and sexual violence service sector, we've got our justice sector, the health sector, education, but how do we join it all up together is going to be really important.
No, that's all good. I might think of something later, but I'll leave it there for now.
Mr. Ng.
Thank you, Chair, and thank you for taking the time to give evidence today. Are you able to hear me?
Yes. Yes, we can. We had IT problems.
Hello there. Can you hear me?
Yes, we can hear you. Can you hear us?
I can hear you, thank you. You mentioned before that it's important to have nationally consistent data using the best available data points. I suppose with your experience having an overview of the Tasmanian family violence sector, what do you consider would be the best data points in terms of reducing the risk of suicide and reducing the impacts of domestic, family and sexual violence? And are there any currently used data points you find both easy to report with and that provide you with valuable information? I'm thinking of places like the Australian Institute of Health and Welfare or Department of Social Services or ABS or any other ones that you have experience with.
I guess in terms of where we get our data from, definitely AOHW and the Personal Safety Survey is really one of those areas that we utilise quite a lot for our research and understanding. I think where the Personal Safety Survey could be more helpful is taking a bit more of a intersectional approach. There isn't really the data that we need to understand Tasmanian Aboriginal experiences of violence, and it doesn't necessarily go into LGBTIQA+ as well. So I think being able to kind of get a bit more of a nuanced data set would be really beneficial to us. In terms of suicide, of course, we've got the TAS suicide register, which we can access and get that information from. But I think there also needs to be a bit more work done around a standardised approach to understanding the risks of family and sexual violence, and then also the risks of suicide and how that data is reported and recorded. The National Risk Framework for DFSV that's currently in development, I guess, goes some way to provide some kind of nationally consistent data and guidelines once it's finished. And certainly looking at that as perhaps potentially a starting point for creating a data set would be of benefit.
Thank you. That's all from me.
Lovely. Mr. Ngasidi did have to leave now, so yes, thank you. We heard just a couple of seconds ago, I'm not sure if you were here for it, from Laurel House about how the rolling up of family and domestic violence and sexual violence, and particularly with child sexual abuse, has some logical sort of interactions and crossover, but also risks losing the nuance that's required for all of them, in terms of there's a lot of commonalities in terms of the response, but there's also a lot of different. Where does your organisation stand on that? Because I assume you represent the whole of the sector and probably a variety of opinions in there.
Yes, that is true, and yes, it's certainly been something that we've been exploring quite in depth. Is how do we do that? And we're certainly in the early days at the moment. But what we're looking at is having separate streams, so having a family violence focus stream, and this is all down to resourcing as well, but having a family violence stream and then a sexual violence stream and then another stream specifically for child maltreatment and child sexual abuse, because I think children sort of get left on the wayside, particularly in the family violence space, and then child sexual abuse can sometimes in this area get left to the side as well. So having its own core focus is important to us, and our focus is having all those three streams, being able to get that information and then bringing that together where it needs to come together in a more joined up approach. So sometimes there'll be crossover and then sometimes there'll be real distinct differences, and how we kind of provide that information will be key. Yeah.
Certainly when we got the terms of reference, that was one of the things that I sort of reflected on.
Yes.
And it was good to see that, and thank you for our Laurel House friends who are still here, that people from the sexual violence sector picked up that this was also relevant.
Yes,
we needed
definitely.
Specific answers there, because there is because it starts with family. There was a danger that we focus on family,
yes.
and
Absolutely,
and
and it
focus
kind
on the rest of it.
Yeah,
so.
yeah, absolutely. So extremely important.
Thank you. We've talked a little bit about the responses for perpetrators, and I guess the challenge that sits between ensuring that we have a response to perpetrator mental health needs that don't actually undermine victim survivor safety and of course accountability for action. Do you have best practice sort of I mean, I know you can't pick a favourite amongst your services, but are there some best practice principles that need to be incorporated in that sort of area?
In terms of perpetrator prevention or
well,
mental health?
particularly around mental health,
Yeah.
but I guess also perpetrator rehab. Perpetrator rehab has more of a focus on accountability as well. But anyway, the service response to perpetrators.
Yeah, in Tasmania we've got men's behaviour change programs. So there's one community organisation that provides that, and then there's government service providers that offer that within corrections. I'm not sure of the evidence around the benefits or how that's actually working in practice. I think a lot more work needs to be done in that space to address men's use of violence, and that, you know, having a look specifically at the underlying causes as well. So I'm not sure of the exact statistics, but certainly there is many perpetrators that have experienced adverse childhood experiences. So how has that then impacted on their mental health, and then is that being addressed within those programs themselves? I think that's sort of something that would be good to understand and unpack further. I don't have that information on hand. I guess in the mental health space around men's mental health, it's certainly a strong focus in Tasmania. I'm not 100% sure if it's still operating, but there was a suicide prevention governance focus, and one of those focus working groups was around male suicide. So that's certainly covered in that space as well. But I think what also needs to happen is a bit more of a nuanced focus on not just, I guess, male suicide, but what's the kind of underlying risk factors and what's happening underneath that to then address that, not just being a man, but that what's happening underneath that.
Okay. We discussed earlier today around the challenge of coroners getting information in order to have an informed coroner's report that actually says yes, there is a background of family domestic violence or a background for somebody who's suicided. And one of the challenges, apart from, as we discussed, a number of the not-for-profits just aren't asked, so they can't provide their information. Part of the other is the use of ways of describing difficult childhood, family issues or relationship issues, rather than actually saying family and domestic violence, child sexual abuse, child abuse, neglect. So those sorts of, I guess, softening of words. And we did hear from someone else that there was a challenge that some people didn't want to disclose and have that stuff written down because it could then also be used against them in the family courts. I'm bringing together a few different people here. Our terms of reference is really around that intersection between family, domestic and sexual violence and suicide. And Tasmania is one of the few places that's actually done a project that looks at that intersection. How would you, what do you think our way forward here is around that requirement to standardise, but also not expose or make more vulnerable victims who disclose?
Yes, and I think I guess it comes down to also mandatory reporting as well, and I guess certainly community services themselves. We want to make sure that that people feel safe and can go and disclose something and not feel like their children are going to be taken away. I think that's that's a real critical issue. I don't know if I necessarily have all the answers to that. Definitely, I think it's quite difficult, but I think it certainly warrants a lot more focus and attention, and perhaps that more of a bringing together community and government services and a number of people to kind of work out, and victim survivors themselves to work out how to do it properly and how to do it in a way that's fair and ethical, and certainly using phrases and terms that I can see the benefit of that in terms of making it not be quite confusing, because I guess, when we get the suicide register data, it's violence and abuse. What does that mean? It could mean a number of different things. So I think, having that more specific information will be helpful, but then at the same time there's that risk of disclosing, and then people don't want to go and access a counselling session or a support service because they're worried that their information is going to be used against them. So I think it needs a lot more consideration. Okay.
Did you want to ask another question? Otherwise, I'll ask Michael McCormack's question.
You can ask him. That's okay.
So, Mr. McCormack, I'm not sure if he's still online, but his electorate is rural and quite large, and so we've had a few conversations about how these sorts of responses roll out in rural and regional areas. And I note that I think you mentioned, a few other people have mentioned that there is a particularly high rate of family, domestic and sexual violence in North and Northwest Tasmania. I guess twofold question: is that what is that a function of? Like, why do you think it might be there more than anywhere else? And then how do services respond to those sorts of pure demographic number, geographic challenges?
I think the response is challenging. Certainly a number of our services, and I'm sure you heard from Engender and Laurel House, that they provide that outreach support and services, that it is really important that you're providing that face-to-face if possible, because I think you can pick up more on understanding and nuance around what's happening for that person. And then certainly vice versa, if that person was to then travel into an urban area for a service, that means travel time away from the family, which might be a risk factor and not even possible, childcare. So there's a lot of other reasons why that's not effective, and therefore outreach is the answer to that. Of course, with the fuel cost at the moment, services are absorbing that fuel cost. That means potentially some organisations eating into their reserves to fund that. So I think that needs to have a serious consideration, which I'm sure is happening at the moment with governments. And in terms of I guess, why rural areas perhaps have a higher concentration of family and sexual violence, it's potentially one, community attitudes is one of the areas, and I guess in a closed section, the reinforcing attitudes within rural areas. And then also, I guess one of the factors around family violence is isolation as well. So if somebody is more isolated, then there's more opportunity for power and control and coercive control and violence to occur, which I guess, coming back to the intersection with suicide, that isolation is a risk factor for suicide as well. So there's those two interconnecting points.
Thank you. You good?
Yeah.
Right. I don't think we have any more questions online. I think that's a no. No. Sorry, I've got
No,
a signal,
Chair. No, Chair.
I've got a
Sorry.
signal group coming up here, so I'm not just playing with my phone, I'm actually trying to negotiate them. Well, look, thank you so much. So thank you for your attendance today. If you've been asked to provide any additional information, I think you offered some, including questions on notice, please forward it to the Secretariat by Friday, 8th of May 2026. Please note that responses to questions on notice will be published on the committee's website as submissions to the inquiry. You will be sent a copy of the transcript of your evidence to assist you with answering questions taken on notice today, and you will have an opportunity to request corrections to transcription errors. Thank you very much. Really appreciate your time. Oh, okay. Right. We will suspend briefly. Our next witness is running slightly late. Ms. Tanya Brooks Cooper to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Sure, Tanya Brooks Cooper, and in a personal capacity.
As a worker?
So I have over 34 years of experience working in the community sector, so the last 9 in Tassie. So my perspective isn't my employer's, it's mine on some of the challenges in the system.
Lovely, thank you.
Perfect.
So I just need to tell you this part. Although you are not required to give evidence under oath, this hearing is a legal proceeding of the Parliament. It has the same standing as proceedings of the House. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live.
I know, I've heard.
Oh, fantastic. Excellent.
Listening.
Oh, okay. Hello, daughter.
Hello, daughter.
Do you wish to make a brief opening statement before we
I
start?
would like to make
Please
a
do.
Great. So thank you for the invitation to appear. So I'm a Tasmanian community services practitioner with over 34 years of experience across child protection, family violence, youth justice and community development. Most of my experience has been in Queensland, so Tassie the last decade or so. I am at the moment the only active core trainer in the Safe and Together framework, which has been discussed, I'm sure, endlessly with you guys. And I'm about to finish my supervisor training so we can layer that in to practitioners. And I've talked about it a lot in this work because I think as a framework it's really cool to hang everything else under it. Gives you some good bones. So I am making this submission as an individual, not on a part of my employer, and I kind of am coming to this place with deep experience because I've worked all over the space. And my life has been shaped by systems that didn't respond well when I was a victim survivor, and my kids have sort of, they've carried some of that trauma with them. So it's kind of personal. When you look at the data and the evidence that you've been permitted and all of the stuff that's been given to you, because I did a lot of work on what our practices, I know you've talked to Engender and stuff, have done, there is a really direct link between suicide and family violence and the impacts of coercive control on people's mental health. What we don't have in our systems is great ways of tracking that. And I think that's a real loss because we track how many women are directly implicated. We don't necessarily always capture the suicides. So I talk a little bit about, and I would love to talk about in my submission, that we cannot understand family violence without understanding coercive control, and we as systems have really struggled with understanding coercive control for a very long time because it's insidious. One minute you wear black, the next minute you don't wear black because he doesn't like it. You haven't even put into your thing that your whole behaviour has changed. So I guess I'd love to talk to you a lot about what this all means, what it all, how we respond as systems to victim survivors, how we hear them, how our system responses. And for us in Tassie, we are such a small geographically isolated area, but we have some really tricky wait lists and access to services issues and systemic stuff that means whole communities don't know how to respond to this, or it's just so embedded in community aspects that people don't know this stuff family violence isn't the norm. And so we're pushing back against that stuff. We're pushing back on a sector, and I think across Australia one of our challenges is we don't all talk the same language. We don't all use the same legislation. We don't all use the same practices. Some are really advanced, some are not. And in the meantime, we've got women and children who are dying and who are being impacted. So my particular passion point is around Safe and Together, hanging frameworks over how do we talk the same language and how do we do this better, because at the moment, I think in terms of our public policy planning, we've got decades of looking at dealing with this trauma and helping people recover while it's still actively happening, while we're still playing this out in our communities, and that's really worrying. So I guess that's my perspective on this stuff is I'm coming to you saying, as a practitioner who's experienced it, let's do better. Let's map this stuff against each other. Let's get our systems talking to each other, and let's make sure our victim survivors and their kids who are family violence victim survivors themselves have the support they need and the access to things that they need. And I've got heaps more, but I think that was my time.
Thank you.
It's never short of a word.
Okay. Well, thank you for that. That's as we were saying, pulls together a number of themes that we've heard,
Yes, I'm sure.
both through the readings, through the 230 odd submissions we've
How
had so
good
far.
was that, though? How good is
Fantastic.
that we care enough as a community that we're stepping up and saying, yeah, we think it's linked and this is where it's linked, and we're worried, we're not counting the true impacts of family violence across our systems.
Yep. So going to your concept of the absence of a shared framework and shared language, part of our terms of reference is very much around that linking of family, domestic and sexual violence, and keeping the, those
Which is so important, which
but
has
also
been,
connected.
because family violence does not stop at the bedroom door.
Yep. But sexual violence is also sometimes a different thing that's not in the context of family violence. But then that and suicide. And so we heard this morning from the Coronial Division of the Magistrates Court about their project where they are data matching those things.
Fantastic.
They've done 2016 to 2020 to date. They're now doing the data coding on 2021. But part of their challenge is access to data. We heard from multiple government agencies about their shared data framework, but we also heard from the not-for-profit sector that they're not part of that and that they haven't been part of
We
the other
don't sit at the
project.
table. We do not, as non-profits, not that I'm speaking as a non-profit clearly, but as a practitioner who works in a non-profit environment, we are often not included, despite the fact that we are often the ones sitting the closest. And in the Safe and Together model, you would be able to argue the closest to the perpetrator by being able to clearly articulate what's going on, but we don't sit at those tables and often are not included in the information sharing protocols, and that certainly hasn't been locked down in Tassie that, for example, if you are working in a family services program and a family violence incident happens, there isn't an automatic trigger to let us know before we head into that person's home or back into their life that something has gone on, which is incredibly problematic.
Yeah. One of the other challenges we heard from, I think this might have been from the ABS, because the ABS does some level of data matching as well, is that often the sorts of data that is available is minimised, and so the sorts of examples we had were, troubled childhoods or families
experiencing family violence because we haven't clearly articulated there's a perpetrator, a victim, survivor and protected
which makes
behaviours.
it really hard for them to then say, well, we're talking here about child abuse, or we're talking here about family violence in the context of this suicide. From your experience across those many sectors, what advice would you give in terms of that data sharing and also the shared language that you were talking about?
Yeah, a really good question, and I guess we've often pondered when we're sitting around the desks at work about how we manage this stuff. I think the federal legislation is probably where you guys have the resources and the skills to keep ahead of the game. A lot of the work that we do, the states are doing that at a different pace and maybe at a different priority, because there's a lot of stuff to cover. So whether there's an opportunity for federally the legislation to roll out and then the states to regionalise it to make sure it works for us. But the information sharing, I don't know how many times you have to use the different trigger points to go, this is in the best interest of the child that you share this information. Now that works when there's kids involved. That's really tricky when there are no children involved to get best interest information. And not all of the systems talk to each other at all, and not everybody has access to all of that systems, and that's not expecting that non-governments, of course, would ever get access to all of the systems. But I think those trigger points are definitely missing. And so if you're a fan of a flow chart or a Gantt chart, it feels like somebody who loves that thing should sit down and go, who should be told when and where does the information need to sit? Because I think there's still a lot of people within our systems who will close. So if it goes into, the child protection system, if the children aren't involved, there's still a perception that we would just close at that point and not consider any further action because the children weren't directly impacted. But we know that's not true. So there's those kind of gaps that are still existing. So we don't all come from, so in a practice base, I guess I'm a Safe and Together advocate, but it's because for me, that whole working with the victim survivor is, as the central platform is the most important thing. And then holding the perpetrator to account, however that might look like, is really in my eyes, the easiest way to sort of figure out who's doing what and what it looks like, and then what interventions fall out of that. You'll be able to offer that much better if you understand what's happening in the system. The other thing that I guess Safe and Together offers, because these cases are often quite noisy, everything is going on. There's he said, she said, there's system collusion, there's all this stuff happening, is that capacity to just write it all down and have a real look at it. And again, Safe and Together may not be the model everybody chooses to go with, but that ability to cut through everything that's going on and just look at who's doing what, who's looking after the kids, and what does it look like for the kids at this point in time? How do we protect them? How do we keep them safe? How do we nurture them in this situation of uncertainty? So I think it's how big's a piece of string. I don't know how you're going to unpack that one, but I think the challenge is somebody needs to be resourced to do the work that sort of sets down what we will accept as a community, and then go from there, support the states to regionalise it, because of course we've got so many Tassie, Queensland has the same issues, but I've been here for, almost a decade. We've got regional communities where an incident happens and police may not be able to respond for, who knows, sometimes weeks before they can get down. Child safety services just don't have the resourcing to be able to respond either. So teachers are holding those strings if the kids are in school. If the kids aren't in school or the person doesn't have any children in their lives, then who's holding their safety in their hands and making sure they've got what they need? And then you look at our service responses, which are magnificently well funded in terms of victim support, but overwhelmingly well funded. There's so many services and you're already overwhelmed and in family violence. But then on the perpetrator change side, or on the how do we work with the person actually causing the harm, that isn't funded well enough, and there certainly isn't many options. And if you look for Tassie, there's a couple of national phone lines you can ring. There's the Inner Boy app, there's a prison program and a couple of men's programs. But there isn't actually any programs to say, hey, you're a perpetrator and this may be not what you want to be. How do we help you change that behaviour stuff? Let's work with you. So, therein lies the challenge as well. We spend all of this money on victim survivor stuff, which is super important, but we're not working on the people who are actually causing the harm. So we're not changing trajectories. And when we're trying to map to suicide, if we don't have anybody working in with the victim survivor to understand what's going on for them, then you are really guessing at what was their motivation behind it. But if you've been working with them, you can make a clinical response to that and say, there's a direct link. The coercive control or the undermining or the physical abuse, the sexual abuse, all of that got so much that this is what the outcome was. So I think that's really tricky, but a really cool question to ask.
Your submission connects rigid gender norms with both DFSV perpetration and suicidality.
Yeah.
Are you aware of any programs, either in school or community or workplace or whatever, that actually are effective in challenging
that?
norms?
So the Inner Boy app, have you come across that one yet? Okay, so Inner Boy was out of She's Not Your Rehab, and it's a New Zealand movement, and he's a barber. And he grew up in really tough circumstances, created his barber chair as an opportunity for men to feel safe. And as part of that safety conversation, he developed a program that's, like he says, if you give him 30 minutes a day for 30 days, he will help you change your behaviour. And his argument is to the men, particularly that he works with, that you're bleeding over the people who didn't cut you. So we need to stop that. We need to stop that behaviour. So that's probably the most effective one I've seen. Caring Dads is a great program as well, because it does that perpetrator accountability, and there's huge amounts of evidence that sort of suggests that you can't go, you're a crap dad and this is wrong. You need to go, what kind of a dad do you want to be? What kind of a partner do you want to be? What kind of a person do you want to be? Are you being that? If not, how do we get you to be that? As simple as it is, what's your carrot to change your behaviours? And I'm not saying it's there's no one stop, it's a change and a lifestyle change, but that opportunity to connect in. And I think the state government at the moment is looking at the Good Lives model for working with the young people. And that came out of working with people, sexual offenders, saying we see you as a person, we don't see you as your offences, and we see you as having unmet needs. Now, how do we help you meet your needs without doing harmful behaviours? So we see you and we value you, and life has probably thrown you some curveballs. You're throwing them at other people. We don't want to see that happen. So how do we do this? So that opportunity to work with change when they're change ready, and in that way, because like Brené says, you put someone in humiliation or you put them in that space of feeling uncomfortable, you're not getting them anywhere. In fact, they're probably going to rip you a new one and it's going to hurt. And you'll probably, for the next worker that tries to come in there, it will take them 6 months to build rapport instead of 3 because they've already been burnt by the system. So I think for us, we've seen great work with caring dads because it hangs under the framework of the Safe and Together model. But I think there's just that, just seeing what other notes I have here. I think those are great programs. And that the rigid gender norm stuff, thank God we're talking about it more. Because I think the man box, have you seen the man box stuff out of, so, you know, not only that study, what that reveals is all the different ages and different perceptions and how men are feeling about themselves, but also hangs on to them that, you know, when you sit in that rigid mode, you're actually really unhappy and you're actually hurting yourself as much as the hurting of people around you. So again, where do we get you to a place where you're more accepting? Because we all do have different, I guess we're socialised differently. We've got lots of things to understand, but that generally packing it down to how do you not hurt anyone? What else have I got? I think I've got some of my recommendations here. So I think it's really interesting that, you know, and then how would you roll that out and how do you make it culturally appropriate? Because we need to have those conversations. You know, how do you roll this out in regional areas? How do you tackle these conversations? What do you do? You know, I'm always curious about what do we do with the people who don't want to change, who don't see an issue, you know, because we've got that playing out as well. How do we as a community encourage our men to stand up? Because I feel like I've been standing with placards for 30 odd years saying don't kill women and wearing the t-shirts and turning up at marches, but since I'm not someone who kills women, that's not tracking change. We need to track change where they are, and is that funding programs to really work with men around you know, who they want to be, who they want to be and how they want to engage and how they want to, and see if that changes things from that gentle perspective. Although then the balance is adult crime, adult time, you know, how do we hold perpetrators accountable if we're not putting them in prisons? So I think it's quite a tangled web. I'm just worried it's getting, either we're hearing about it more or it's getting more pervasive because the deaths keep on coming and the children impacted just keep on coming, and then we've got generations coming forward that we're still, you know, I'll never be out of work, but I would really like to be.
Thank you. Mr. Gregg.
Thank you for that, and for your written submission, which is a very good synthesis of a lot of other evidence as well, so greatly appreciated.
I think I was worried I'd gone too broad, but also I took lots of the things other people had said because they have said major. And again, I work on the periphery, so that, you know, my space is on the periphery, in with young people and with families and stuff. I'm not in the main systems. We're negotiating around the edges.
Well, I might focus on young people initially then.
My favourite.
Obviously, young people both, you know, directly impacted as victims, and also the impacts on them as part of a family unit where abuse is present. One thing I've noticed in Tasmania, there doesn't seem to be a lot of youth-focused services for those particularly unescorted youth, like a 14 or 15-year-old who's part of that environment, to outreach directly. And then also those that might find themselves in relationships where there is intimate partner violence as well. Not to mention adolescent and child intra-family abuse as well. So is there a kind of ideal service model in your head for young people?
Is there an ideal service model? Yes. So again, for the youth sector, traditionally, and I say this controversially, very underfunded for decades. You know, low expectation of workers that come into this field, that, you know, maybe not much qualifications. It's seen as babysitting, but actually some of the foundational moments, you know, there's so much research that says if you can be the one safe person for a young person, you can change their trajectory by just being that safe person. So there are a number of programs. They don't talk to each other very much. I know when I was looking a few years ago for a program for young young men, so year 8 and 9, dad was weaponising them to contact mum. And I could not, for love nor money, find a service to go in and talk to the cohort about what is family violence, what happens if somebody's, what is an order, what does an FEO look like, what are the requirements, what should you do what if you're feeling uncomfortable, just to talk to all of them, get that peer education up. About what should you do if this kind of stuff happens, because it needs to be a mix of the psychosocial stuff. It needs to be that pro-social modelling. If they've never actually seen what a safe relationship looks like, we as workers need to provide that. And that goes from the minute we put our first conversations to they hop in the car, to our driving, to our how do we handle conflict, is showing them those particular strategies. And yeah, so I think, yes, there are some great models I think that we could talk about, and it needs to sit with one-on-one work, group work, community education. Their prefrontal cortexes have still this chance. They're still all elastic. So you can still get in there and talk about what kind of a parent have you had? Do you want to be that kind of parent? Or what kind of adult do you want to be? Do you want to be like those adults to try and turn the tides? Because a lot of the young people that you see have just had terrible lives. Like, they are not the people committing those crimes because they want to. They've just been put in such really untenable situations that's what they're doing. Or, they've been homeless since they were 10. 10-year-olds should be worried about, I don't know what, their first boyfriends and homework and being invited to a party, not about where to find a bed to sleep. So I think if we were doing the models, we would look at school social workers in the schools are there maybe a day a week. That's not enough. 400 kids in a school 1 day a week. Our services, frontline services, are hideously underfunded. And back to that age, some are funded federally, some are funded state, some are funded philanthropically. There's no coordination in there. We've got Why Not, which is our youth board that doesn't actually have enough money to get us all together in the same place for us to do the networking. Schools are carrying more than they actually should. So it's the perfect storm of young people falling through the cracks. And there are pockets of money going into programs. I think Engender got one through Our Watch the other week that'll work with dads and LGBTIQ young people, but it's a pocket, and if it doesn't have ongoing funding, and that's not going to be an issue that stops, then we're not gaining that traction there to change, that peaceful nature of funding. There's some funding in it at TAS that will work with young men, particularly who are showing perpetration tactics. But there's a huge wait list. You've got to convince the young person to go. They've got to think they've got a problem. So all of that. So, if we could create more gentle entry points, so more support in schools, more avenues for support, looking at how we can spend time with each and every young person and do that early intervention before they escalate. And once they've escalated, allocate enough funding that workers can actually get in there and be their safe person. Maybe they only carry a caseload of 5 so that they can actually spend the time it takes with those young people every week to be stable. Because if you think about when was the last time you tried to put a housing app in, or go to Centrelink, or just set up a mail redirection in your, like, each of those are a couple of hours each. And if you've only got a couple of hours with the young person, your whole session with them is spent on an appointment, not on any of the work you do around that appointment. But acknowledging it early and doing some of we know that this stuff has an impact, and we know that impact can either be that the young person moves away from it completely or they delve into it. So getting before they're making that choice and supporting them there.
In terms of timeliness, there was some evidence, I think, from Victoria that particularly perpetrators who are help seeking kind of really only generally do it for a narrow period, like 35 days. And if you don't capture them then, it's very difficult to get them back in. So would it be fair to say that resourcing of those services has made timely intervention difficult? And if so, how significant is that in inhibiting our ability to intervene?
Well, yes. So if they... And I'm surprised you say 35 days, because I think there was some research when I was at Victim Assist Queensland in 2011, 2012, where it was 1.6. people would try 1.6 times to get a referral, and if it didn't work, they would walk away. And that was around victims of crime. So I'm surprised it's that long. But yeah, and the problem that we have then is there's a system, if we let people down, it takes longer to rebuild the trust. We also, we've moved away, I think, in the last few years from the no wrong doors situation as well. I think Orange Door does it work really well. But there is a wrong door, and there is wait lists, and there is nobody answering phones, and brochures talking, we don't always get very accessible in how our information is, which is why I think the Inner Boy one goes really well with people, because it's just person to person communication. And the worry then is if they help seeked and it didn't work, or they hit shame. You hit a worker who doesn't understand the impact of shame, humiliation and embarrassment, then you and I wouldn't go back. Certainly a perpetrator wouldn't go back as well. So that, again, when we're not talking the same language across all the different sectors. And when you talk about for perpetrators, quite often they are sent for anger management. Now, anger isn't their problem. Power and control is their tool of trade. So anger management, they get the certificate. They've done the course. They've turned up. But since they weren't punching the guy at the petrol station and they weren't probably fighting with anyone in a workplace, it's not an anger management issue. It's a family violence perpetrator issue. So then we've got this thing that they're passing training. They're not necessarily sitting in the space where they've changed behaviours. And if alcohol and other drugs is dealing with their addiction, but not talking about their perpetration, we're missing the point. They're in getting their mental health support, but we're not talking about their perpetration and their opportunities to change. Every single time the system doesn't work together is a time we're missing an opportunity to change a perpetrator's behaviour. And from a victim survivor point of view, and for the kids, it's another missed opportunity to keep them safe. And perpetrators as a whole are missed out of so many conversations. We're still a society, we're still patriarchal in our society things. So when a school rings, do they ring mum or dad? When they're ringing, if the people are asking, do you have children? Sorry, it's personal, but they would probably say to your wife, who do the kids see versus you? Because that's still not a conversation. It took us 3 years to train our school to ring my husband when my kids got sick, because he was working from home a kilometre away and I'm travelling all over and doing all of this stuff, because they just ring the mums first. Mums still get a morning tea, dads get... So we're still patriarchal. So I guess my argument here is we need to do some of that systems work ourselves on how we respond to things. Child safety needs to be sitting in his lounge room asking what he's doing to keep his children safe, not in her lounge room if she's not the perpetrator. And we've got some, some space to do. And if perpetrators reach out and ask for help, we need to be ready, and we need to jump at that point and go, what does that look like for you?
So in terms of, I guess, identifying effective interventions, there's reports recently around funding for suicide supports is sometimes very difficult to kind of equate with successful outcomes, and the measurement of programs is very difficult. Firstly, how do we measure success? And secondly, there's an argument that we are under measuring the relative success of programs.
I know. I remember years ago arguing with a youth service funder that getting a kid to come back was actually a KPI, because they have, most of our services are voluntary. So them choosing to re-engage with you is actually a huge KPI. It's not very funding friendly, but it is. The fact they came back.
But I guess then linking it with the purpose of the funding or the program, is it fulfilling that purpose?
Probably not.
Would the same be true in relation to the family, domestic and sexual violence space? That are we good at measuring the relative efficacy of programs, or do we go, they're doing a good thing, so let's just keep it going?
Ooh, that's a really... I guess that my question back is, has much changed in the family violence sector over the last 20 or 30 years in terms of, I know we've increased the funding, but how much have we actually changed about the way we're funding services, given that we know the perpetration is changing faster than if you could get on the dark web, you would, but the perpetration is changing. Are we changing as our sector? For example, are people funding for, I remember Jess Hill talking, and I hadn't heard about it happening down here, so I was able to get her down, but talking about how many trackers are now existing. But I don't think there's tracker removal funding in our funding You know, that's usually gone and outsourced and philanthropically funded. But in fact, for safety, for all of the victim survivors in shelters and stuff, we need to get those trackers off. So my question back to you is then, is the government able to respond at the same pace that the offending and the perpetrating is changing at? Because back to my argument, if we're funding the victim survivors and not talking about the perpetrator, then we're band-aiding, we're not dealing with the knife.
It's also, you know, are we collecting the right evidence, and then is that evidence informing the design of programs and systems that we then fund?
And are we letting victim survivors be part of those plannings? Because they essentially, no, they are not a homogenous group by any means, but they at least understand what it's like to be living like this and what would have helped in those situations. I know I did a little bit of work at one stage in victim survivors when they were being put up by the police, and you know, everyone's contacting them. We want to help, we want to help, we want to help. They all ring on private numbers. Their names are so similar. There's 100 brochures, and meanwhile this woman and her children are just terrified. You know, so even the way we do those responses, what's the most trauma-informed, kind, you know, way that we could offer support when people are in that critical mass? And for victims and for perpetrators, at the point you've perpetrated and you need help, who do you reach out for and go, actually, something's happened and I need help? And I don't think there are those services for that. And how would we measure that? Well, wouldn't it be nice if no one died? Police stop being called to family violence incidents. But you know, that links to, you know, we rely on police and their legislation is largely around what situations, not, we know that perpetration is a pattern of events. So they turn up and they see what they see and they have to act on what they see. And if the perpetrator is skilled, he's standing in the front yard with the kids saying she's inside and she's gone off and the house is trash and I don't know what's going on. And all of a sudden he's looking like the protective parent and she's looking like someone with an order on. And then that order gets breached and she loses her working with vulnerable people card. She can't work in most of the careers that are lined up for, you know, people, you know, so we play this game of complete power and control over who she ends up being, and the system is well and truly in that space. How do we measure perpetration? Maybe they're not perpetrating.
My final question, particularly, I guess, Tasmanian experience, but also your experience nationally. Are we locating and targeting services and supports to the cohorts with the greatest risk factors, or is there an overpropensity to put services where there's greatest population, even if the risk?
Oh, yeah, we definitely are not. If you're asking, are we serving regionally, I think that would be across Australia, never enough in regional areas, because that just, and perpetrators love to move people to small towns where they know the police response is 4 to 6 weeks, you know, weeks away or hours away, and it hides them. So no, we definitely still fund too much in bigger regional areas and not enough in communities that need it. But keeping in mind there's a whole lot of stigma around this work as well. So you would have to be, I remember I used to work with someone in the middle of Queensland, rural Queensland, and she was with an agency and she would say to the people, if I'm in uniform with a lanyard on at IGA, talk to me. I'm probably in work time. But if my lanyard is off and my collar is up, please don't talk to me, I'm off work. Or alternatively, that worker used to use the storeroom of the IGA to have conversations because that was the only safe place to have a conversation because people weren't able to come to services. So I think that's back where you go to victim survivors and say, what would it look like for a service, and to perpetrators, what would a service look like to you? Where would you go? What does that feel like? You know, is it an online thing? Is it a face-to-face thing? What would it feel like and look like, and what would make you go? Because designing it for people who aren't perpetrators, who aren't victim survivors, we have no idea that 24-hour surveillance, the terror that they're absolutely living in, and that proactive safety planning they're doing all the time. Like, that is just, I think it takes decades for your nervous system to unwind after that. And there's a whole lot of research now actually in the polyvagal theory and how family violence actually, the perpetrators will actually wind your polyvagal responses back so you don't recognize it's fight or flight anymore to make you an easier target, but that will then go on to affect you in multiple parts of your life. So a lot of work we do with women is helping them reconnect and calm their polyvagal to feel that fight or flight so that they're able to then recognize what situations they're heading into.
and then also wind down the hypervigilance.
Yeah, which is so difficult to do.
Now, Michael McCormack has a question. Mr. McCormack?
Thank you, Chair. And I really appreciate the evidence you gave. It was absolutely fascinating, sobering too. Thank you for the work that you do. You just mentioned regionality and rurality. I'm a regional member, and I'm interested to note, is that based on work that you have done, research that you've read, data that you might have taken part in, anecdotal evidence? How do you, and I absolutely 100% agree with you, victims in regional areas are very much behind the eight ball when it comes to being able to report, getting the services and support and help and wraparound assistance that they require. So could you just in the time we have remaining, and I appreciate it is fleeting, but could you please just sum up for us your experience with regionality and this matter before us?
Sure. So I have worked in regional communities like Arakoon, I've worked up in Cohen, I've worked across Tassie, Cherbourg, different communities. So I'm speaking from experience, but I'm fairly sure we could dig some data up, and people who've done more than enough studies on this that just respond to regional communities tend to be geographically isolated from so many different services. In fact, some of the work Hobart City Mission did that we did earlier in my time in Tassie was actually trying to get regional mainstream services up to regional areas so people didn't have to drive. So it is really well noted, but that, this comes down to how much are we going to invest in our communities? Are we going to invest in place-based solutions where people get trained up locally and are able to respond locally to local issues? And I think the answer for us is yes, that's what we actually need to be doing. We've got fantastic infrastructure that we can use, and we've got research bases, and people are really interested in this issue at the moment, as they should be. But I think we should be looking a lot more at how can we resource small communities to respond to their own issues and train them to respond, and then wrap our systems in around them on what they're actually going to need. Because, what will work in Cohen won't work in Georgetown here or something. But I think I could probably dig up a heap of evidence on that. But I know we've studied that kind of stuff on how do you get workers out. And of course, the other thing that funding happens is you fund an agency in Hobart to deliver in Oatlands, but they drive, they start at 9, they hop in the car, they get up there by 10, they're ready for work by 10:30, they need to be gone by 3. So even when you're resourcing a worker in a regional community, you're not getting an 8:30 to 5:30 day out of them. You're getting transport time. And that loses some of the impact. And we also know for this kind of work, you've got to build trust. So you need to look at the longevity of your staff. How do you resource this servicing to go over, it might take 12 months. It could take 2 years to have a relationship with clients that they feel like they can trust you enough. So how do we fund for that kind of longevity to allow that trust to develop? Also, Hobart can't change behaviours in Oatlands. So, if everybody's working from the same page and with the same agenda across the state, maybe all the country, is there a hope that we're starting to look at changing the community perceptions of this and people changing their behaviour?
Thank you. I really appreciate that. Thank you so much.
Thank you. Look, thank you so much for coming in. So thank you for your attendance today. If you've been asked to provide any additional information, including questions on notice, please forward it to the Secretariat by Friday, 8th of May. Yep. Please note that responses to questions on notice will be published on the committee's website as submissions to the inquiry. Perfect. You will also be sent a copy of the transcript of your evidence to assist you in answering any questions taken on notice, and you'll have an opportunity to correct any transcription errors. So just let us know.
Make me sound smart. Thank you.
Feel free. For those in person or listening online, if you've heard anything today that's upset you or caused distress, please reach out to the support lines 1800 RESPECT, Lifeline, 13 Yarn, Kids Helpline, or any other support services. There is also Parliamentary Workplace Support Service and Employee Assistance Program for Broadcasting, Hansard, the Committee Secretariat and the committee itself. I now declare this public hearing closed.
Chair, could I just ask a question offline?